One is company appeal, one is claimant's appeal.
Relist on date.
Other one?
On what ground liability? ಆಯ್ತು ಕವರ್ಡ್ ಅಂದ್ರೆ ಅಡ್ಮಿಷನ್ ಅಲ್ಲಿ ಹಾಕೊಂಡು ಮುಗಿಸ್ಕೊಬಹುದು.
ಕವರ್ಡ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಏನಾಗಿದೆ ಇದರಲ್ಲಿ ಅಂದ್ರೆ ದಿ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಈಸ್ ಡೆತ್ ರಿಪೋರ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಪೆಂಡಿಂಗ್ ಫಾರ್ ಫೈನಲೈಸ್ ಅಂತೇನೋ ಇದೆ ಅದರಲ್ಲಿ. ಅದಕ್ಕೆ ದಟ್ ಇಸ್ ಅದೇನೋ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದಾರೆ
ನೋಡೋಣ.
Place of week's time finally, Lords.
Week's time granted for necessary compliance finally. Relist the matter on date good.
Please.
28. Each time granted finally, relist the matter date good. Relist the matter same stage. So you file whatever you want to file. It is submitted that on 15/6 ಮತ್ತೆ abate ಆಗುತ್ತಲ್ಲ, unless you take steps. I'll say abated and leave it at that. You take steps. Lord Counsel for the appellant submits that the sole appellant died on 15/6/2023. In light of the same, proceedings stand abated. Yes.
Respondent number 3 filed the affidavit, my lord. Only one set is filed. Last occasion, your lordship directed him to file the second set also. In spite of that one, he is not filed the, but he complied, my lord, but only one set is filed. He is not appeared also. Last occasion also is not appeared.
ಯಾರು ಲಾಯರ್?
First time I'm Chandrasekhar. Yes,
ಅಲ್ಲ ಅಷ್ಟೇ, ನಾನು ವಾರಂಟ್ ಇಶ್ಯೂ
yes, my available warrant may be issued.
ಅಲ್ಲ, does it amount to compliance?
That is, my copy is also not given to us. Update ಬಂದಿದೆಯಾ?
ಅಲ್ಲ ಅದಾಯ್ತು.
Comply ಮಾಡಿದ.
ಇವಾಗ ಫಸ್ಟ್ ಸೆಟ್ ಆದ್ರೂ ನೋಡಿ
Comply
compliance ಆಗಿದೆಯಾ ಇಲ್ವಾ ಅಂತ. Then means I have a look at it. I'll pass over. Let us
ನೋಡ್ರಿ
court set, have a look at it. ಆಗಿಲ್ಲ ಅಂದ್ರೆ we will see what is to be done. Who is that official? R3?
R3 is the lord here the irrigation. Commissioner, City Municipal. R3 is
Executive Engineer, RDPRE Project Division, Kalaburagi.
Executive Engineer, sorry, Executive Engineer, my lord. RDPER project. He filed the affidavit.
I'll pass over, but it reflects very poorly on the council representing. So last time also he didn't appear. It's not done. Not in contempt proceeding. ನಿಮ್ಮ ಹತ್ರ ಏನಾದ್ರು ನಂಬರ್ ಇದ್ರೆ ನೋಡಿ ನಿಮ್ಮ.
Only one, our department is sent one letter, my lord, that's all.
RDPRE ಅದೇನೋ ಅಲ್ಲಿ ಏನು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ ಅದಕ್ಕೆ?
ಯಾರಂತ ಗೊತ್ತಿಲ್ಲ, he is not the standing council.
For that RDPRE ಬೇರೆ ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಇಲ್ವಾ?
In the before
Fast
load a
track.
single judge, my lord.
ಅಲ್ಲಿ ನೋಡಿ ಆತ ಎಂಟಿಟಿಗೆ ಯಾರಾದ್ರೂ ಲಾಯರ್ ಇದಾರ ಅಂತ ಚೆಕ್ ಮಾಡಿ.
But government is appeared, my lord, in the writ petition. But in the contempt petition, my lord.
ಯಾರಿಲ್ವಾ ಕೌನ್ಸಿಲ್ ಅದಕ್ಕೆ? ಇಲ್ಲಾಂದ್ರೆ ನೀವೇ ತಿಳ್ಕೊಳ್ಳಿ ನೋಡ್ರಿ.
PRAD project. PRAD, Panchayat Raj Engineering. Lord, Panchayat Raj Engineering, Rural Development and Panchayat Raj Engineering.
ಚೆಕ್ ಮಾಡಿ.
Or Panchayat Raj Engineering, RJ Busari appears now. Panchayat Raj Engineering. But here it is already. Just verify once.
Panchayat
Just check.
Panchayat Raj.
Panchayat Raj, then it is RJ Busari.
You just call him.
Please.
Please. This council on record, he has filed one set. Last time he didn't come. We passed it over, he didn't come.
Please.
Today again, he hasn't come. You can't represent like this an authority in contempt proceeding.
I'll inform my lord.
Call Busar.
Please.
You have his number?
Busar, I have his
Call
number.
him.
Please.
Yes, also. For respondent number 2. Learned counsel.
Wow.
Supas Sagar Patil is directed to accept notice for R2. Relist the matter on next week date could. 25th. Yes.
Respond number 5 in this one.
Each time granted finally to take necessary steps for R1, R2, R4 and R8 as well as regards R9. Yes.
Please.
Counsel for the appellant has filed a memo which reads as follows. In light of the same, appeal the petition is dismissed.
Bill.
Yes. Good. ಇನ್ನೊಂದು ಕೊಡಿ. ಅದಿನ್ನೂ ರಿಲೀಸ್ ಆಗಿಲ್ವಾ ಇಲ್ಲ? ಪಂಚಾಯತ್ ರಾಜ್ ಆಕ್ಟ್. What does rule 3 say? Forty-nine. Rule 3. No, I'm saying the single judge has said that without reference to 49B1 proviso. So what act? No, I'll come to the, I want to know which provision that is. Act or the rule? Act. So you take us through that provision. 49B1 proviso. Adhen amend agidya ado? Is it an amended provision? So what does that provision say? That will come to that. I want to know what is that 49B1 provision? Illa. Adella ಆಯ್ತು. So what is that provision?
Your lordships, if I'm permitted to submit, your lordships, that provision is with regard to submission of another no confidence motion after the first no confidence motion is negatived or your lordships favored in favor of the president.
So
Yeah.
which is that provision? I didn't
For-
find it in the statute book.
It is amended, your lordships. It is amended.
Ah.
Till your lordships time period has been prescribed for a period of 6 months. If first no confidence motion has been taken place, the meeting has taken place, then from that date, another 6 months, your lordships, another no confidence motion
So
cannot
where
be
is
made.
that provision? Where is
40
that provision?
49B1, your lordships, that is,
We'll have a look at it.
yes, your lordships. That is not applicable to the present case, your
What is-
lordships,
What
because,
is this? Just 1 minute, just 1 minute. What
Yes,
is this council? You're appearing as an appellant. Must you not know that there is a provision? He is saying it is there, it's amended ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ. Counsel for the respondent is saying there is such a provision after amendment. Then something is wrong, that's all.
your lordships, that even that would not be applicable.
No, that we'll see, but I want to know whether there is a provision or no.
Yes, there is a provision, your lordships, there is a provision.
There is a provision. When is the amendment? When is the
Yes,
amendment?
your lordships.
Ah.
2020, your lordships, 2020, and another amendment has taken place in the year 2022.
22.
Yes, your lordships.
Yes, what is that? 49 and review on the provision.
Earlier it was within 2 years, your lordships, and later it has been amended
I
as
want
within.
to see the provision, council. I want to see the provision.
Okay, yes.
Appellant says there is no provision only.
Your lordships, there is a provision. In fact, there are 2 judgments referred, your lordships.
Amended itre kodi. Amended itre kodi. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಅದು? ಚೆಕ್ ಮಾಡಿ ಕೋರ್ಟ್ ಆಫೀಸ್ ಇದೆಯಾ? ಆಯ್ತು, ಮೇ ಬಿ ಅ ಮಿಸ್ಟೇಕ್. ಆಯ್ತು, ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀವಿ, ತಗೊಂಡ್ಬರ್ತೀರಾ? ಅಲ್ಲಿ ನಾವು ಓದ್ಬೇಕಲ್ಲ. I want to have a look at it. Why don't you go to the library, get a printout? Your case, isn't it? Your case is that the court could not have passed an order doing away with the mandate of 49B1 proviso. That is your case. That other one we'll see. First point I want to know, that is the ground you have raised. That we'll see. What is that liberty? That without reference to 49B1 proviso. I want to have a look at that 49B1. If you're saying 49B, ಆಯ್ತು, 1B ಇದೆಯಲ್ಲ, ಅದು ತಗೊಂಡ್ಬನ್ನಿ. No, I'm not going to read that. Get it from the library. Pass over. ಅದನ್ನೇ ತಗೊಂಡ್ಬನ್ನಿ. Let us have a look.
At 2:30, your lordships. If it could be taken at 2:30, your lordships.
No, 2:30 we are not, we are breaking. Bench is going to break.
Yes, sir.
So You can appear through VC if you have a problem. That's not an issue. Let him, you intimate him and you come, we'll ask him to log in. No, no,
Gratefully.
I want to get, second case is linked to this case. So what is that 49B1? If the first case you succeed, second case doesn't arise. But according to me, so I want to see that provision. We'll see what is to be done. Then we'll see the second. We'll till 1:30 we will be here. Next.
Onto them.
You're seeking for transposing.
Yes, yes. This the appel number 2 died.
So what is the position now?
Yes.
What is the position if the appellant dies?
No, appel number 1 is alive. Appel number 2 died. LRs didn't turn up to file or come on record or they have not approached. So I have filed an application to bring them on record.
That IA is served.
That copy is served.
Who has filed wakalat?
Nobody has filed it.
Now what would be the effect now? If it is abated, what would be the effect?
The suit is for partition and separate possession. All parties are necessary parties to the proceedings, Your Lord.
So we'll transpose them and.
Yes, yes. 8 and 9.
Appellant number 1 is also died.
Appellant 1 also has died.
Yes, sir. That also he has filed application.
That is already on record.
That's allowed.
Other is allowed.
Not allowed.
Allowed.
So now only in so far as appellant number 2 pending IAs have to be disposed.
Yes.
Okay. IA 1 of 23 is for condonation in delay in filing application to bring LRs. 2 is setting aside abatement. 3 bringing LRs of A1.
Appellant number 1.
Transposing Yava A.
In the same IA I have prayed, Your Lordship.
Yava A 2 of 23.
Yes.
Huh?
The 1 of 2 of 23, Your Lordship. Appellant number 1.
How are you?
Yes, appellant number 1. I beg pardon, Your Lordship.
Okay, you take us to the IAs one by one. Which
Yes.
IA?
Appellant number 1 is died, Your Lordship.
Hello, that is allowed or not yet one?
No, that is not allowed, Your Lordship.
Not
The
yet
pardon for that.
I'll pass over, just have a look at the IAs from the file and tell us we'll allow the IAs.
IA number 2 of 23, Your Lordship.
IA,
2 of 23.
that is setting aside of abatement in respect
the-
of deceased appellant number 1. Just have a look at the IAs.
2 of 23 is for bringing LRs of the appel number.
Illa.
IA 1. 2 ಒಂದಕ್ಕೆ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಲ್ಲ appellant 1 ಬೇರೆ ಸೆಟ್ ಇದೆ, appellant 2 ಬೇರೆ ಸೆಟ್ ಇದೆ.
Yes.
ಅದು ಯಾವ IA ನಂಬರ್ ನೋಡಿ ಹೇಳಿ. I'll pass over, you just tell us the IA. Pass over.
Fine.
Yes, next. Yes.
My lord, here, respondent have filed IA for early hearing. First week of February date may be given for convenient both parties.
relist the matter.
My lord, the respondents are aged about 70 years.
We'll fix a
48
date.
persons. And respondent number 3 is the Anganwadi teacher. She was retired. Now there is no sources of income them. For
We'll-
that,
We'll fix a date. IA is allowed. List for final hearing. Date code, first week. 4th of February. Both sides to file their synopsis
No.
by the next day.
Much.
Take it.
Days in filing the.
Who is the contesting respondent?
Lord, the contesting respondent is Lord, the respondent 1. The period is already over and they are not interested because that period is already over. The legal issue involved in this is Lord, I was contested for the, I had contested for the election of Gram Panchayati from the general ward. And the first respondent had contested from the scheduled tribe, Lord, so reservation, very same ward. And he was defeated by one Smailarappa. He has not been made a party. There are all the issues, Lord, technical, on merit, and the provisions. The technical, Lord, he has not been made a party. Then subsequently, the election petition was amended after almost 1 year. They deleted some portion from the election petition and even in the prayer. This is on technical side. And I was declared, my election was declared as a null and void on the basis that I was holding a office of profit under section 12G of the Panchayat Raj Act.
Office of profit.
Office of profit. And my lord, it was read with section 9A of the RP Act, Representations of the People's Act.
So your election, you were held to be disqualified.
Disqualified. It's not my election, based on that, my election was held as a null and void. So my question is, my lord, the first is, there is a defect, he did not, he was contesting from the scheduled tribe.
No, correct. Now we'll hear you, but you must give us one authority
Yes.
to state that though the term has got over, that it affects you and accordingly you want a finding to be recorded.
Yes, my lord, because in my view, my lord, the order of the learned single judge is not in accordance with law. That is my, otherwise if that remains, my lord, in my view, my lord, what I understood, the combined reading of all these sections, RP Act and the 243F of the Constitution Amendment, how they are to be dealt with. I'm a lord, I was not holding any office. They say that I was a private electrical holding a license, the contract license, electrical contract license, private license.
No,
I was given the work of KEB.
Correct,
They
sir.
say that KEB is an article 12.
No,
It
that's
comes,
correct. That's on merit, sir. But you get one authority to state that your cause of action to sue still survives.
even after the period is over.
ಏನಾದ್ರೂ ಒಂದು
ಇಲ್ಲ ಒಂದು ಇದು ಸಿಮಿಲರ್ ಕೇಸ್ ನಲ್ಲಿ ಇಲ್ಲೇ ನಾನು ಮಾಡಿದೆ ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಪೀರಿಯಡ್ ಓವರ್ ಆಗಿತ್ತು.
No, correct. We will hear you.
Yes.
On that. The technical point, you are right. You give us, you can draw parallel in matrimonial cases.
Yes.
Sometimes though the spouse dies.
Yes.
Supreme Court has said because civil rights will be affected, etc. So even if the spouse dies, we hear the matrimonial appeal. Like on those grounds, you get one authority to show that you have a right to
Still persist.
to
Still.
stand vindicated.
Yes.
We'll have it next week. You get another, we'll hear you on minutes. Relist on date.
ಅಲ್ಲ ಡಿಲೇ ಮೇ ಬಿ ಕಂಡೋನ್.
IA of 2023 seeking condonation of delay is allowed excepting cause shown. Or
And,
relist the matter.
within 30 days, my lord, your lordship knows under section 15 of the Panchayat Raj Act, anything, any amendment should be within the limitation. There is no provision under the any act or any of the orders passed by the Supreme Court or this honorable court that extending the beyond 30 days. No,
Correct.
that
the
is
pos-
the well settled.
Ah.
Even in the so Rajasthan case, that issue was again reiterated with Supreme Court in 2022 or 21.
Let us see. On this technical point, give an authority, we'll hear you on that.
Yes,
Relist on.
it is both on technical as well as on merit, whether the holding of a contract, private contract,
Amounts to a
amounts to holding of office of profit.
Subprop. Yes. Yes. Grateful. 20. When you want, you take it.
24, madam. 31st.
I 31st. Yes.
I'll give the synopsis also.
Yes, yes. Have you been disqualified as well as suppose it says you are disqualified and we cannot then yes.
If they have filed another writ appeal, my lord, that is connected.
Yes, my lord.
If I am the party made therein, my lord, I'll take notice in that and the copy may be served to me.
Sir, the copy, my lord, and in the same writ appeal, we have to file additional documents. I seek a short accommodation.
For respondent numbers,
I do not have the copy.
past title source. 20237.
Respond by 10 I appear.
Learned Counsel Hema L. Kulkarni accepts notice for R10 in
R10.
13.1. Then government advocate for
Please.
In second method.
37.
1 to 1.
One to six, my lord, 1 to 6, I.
Government advocate accepts notice for 1 to 6. 7,
Lordship, this is 13.2.
13.1.
13.1, my lord, already all are served. That is my appeal. And then,
13 is your appeal.
yes, yes,
13.1 is
yes,
Ambedkar's appeal.
please,
In 13.1,
please,
you have accepted for 10.
10.
1 to 6 government. 7, Chief Executive Officer Zilla Panchayat Raichur.
Gaurish.
Gaurish Kashan.
Gaurish S. Kasham for R7. Then 9, government.
Please,
8.
8 I
Division.
take.
8 and 9, government.
Please.
8 and 9, government advocate.
Please.
9,
Government.
9 is the aim of them. Member secretary.
10 is.
10 member secretary.
10 you have accepted, isn't it?
9 is.
Relist the matter on
23rd. Before that, a copy be served, no, because senior counsel
copies
is
of
I'll serve.
appeal memorandum to be served
Please.
on council for the respective respondents. List the matter on
23rd.
23rd is okay.
23rd.
Please.
Grateful.
Now, what is the point?
The petitioner in the writ petition has challenged the order of dismissal, my lord. The learned Singh judge allowed the said writ petition. He had the reinstatement was allowed, but without back wages. So we had filed an appeal challenging only that part where back wages were not. The learned
You are
counsel
for the employer.
I am
Yes,
the employer, member secretary, who has
Challenging
passed the
the reinstatement.
termination order, my lord. I had no opportunity to file the statement of objection therein to contend that there was already allegations against him, my lords. Therefore, the appeal is filed. So if both are connected, my lord, it could be.
That is,
please. Much.
file your synopsis also.
Please.
Yes.
Appearing for the appellant, appeal by the my lord beneficiary, there is a delay of 470 days in filing appeal, my lord. Order passed by the reference court. It's enhancing, my lord, from 1,10,000 per acre to 1,12,556,000.
How much you'll deposit?
That's,
You are for the beneficiary.
yes, yes.
So how much you'll deposit?
Let's may I take notice on delay application, so thereafter I'll take.
Issue notice on IA and main. PCR to be summoned.
R1, my lord, emergent notice, and R2, government advocate may be direct.
Government advocate directed to accept notice for R2.
Yes. There are other connected matters also, my lord, so that I can,
List along with
I will give the notice.
court officer ಕೊಟ್ಟಿರಿ.
Yes.
For the petitioner, lords, order of detention, lords, passed by the respondents under the provisions of Gunda Act, lords, is under challenge. Lords, had disposed of earlier writ petition, lords, on the ground that writ of habeas corpus would lie against the pursuant to that, lords, this writ petition is filed.
And now you take your stand.
I'll take notice, my lord, I'll, 2 weeks, my lord,
1 week.
file the statement of objection. Because I'll
Right.
get the records of the, my lord, even advisory board also.
ಆಯ್ತು.
ಅಲ್ಲ, 1 week, lords,
ಬರಂಗಿಲ್ಲ ಮತ್ತೆ time.
in fact,
directed
one,
to accept
one
notice.
short submission I would like to.
Yes. Yes.
In fact, lords, the detaining authority, that is the deputy commissioner at the earliest point of time, had rejected the lord's prayer of the sponsoring authority, that is the police, for passing an order of detention under the provisions of Gunda Act, on the ground that the materials so far collected were not sufficient. He returns the proposal with a this thing, that if there are any further cases are registered, they can submit fresh proposal. Pursuant to that, they register fresh cases against the petitioner, send the proposal and pass order of detention.
Let us,
Yes.
government advocate to complete instructions by the next day. List the matter on next week. 24th.
ಅಲ್ಲ, next Friday. 24th. ಸ್ವಲ್ಪ ಅದಕ್ಕಿಂತ ಮುಂಚೆ ತಗೊಂಡು.
22 next week. 23rd, let him complete instruction.
Yes,
Now, if you have to set it aside,
Please.
yes,
ಏನ್
record, sir.
ಹಾಕ್ತಾರೋ
I
ಹಾಕ್ಲಿ.
also have a book of compilation notes. I will file it in the registry, which were notes the material notes for detaining the petitioner, petitioner's husband. That I will submit along with the memo before.
23rd.
Please.
Okay.
Accept notice for respondent 1 to 6.
IA 1 of 25 is allowed, and production of English translation of copies of annexure D to H is dispensed with for the present.
And one more IA is for dispensation.
And IA 2 of 25 also
For
dispensation of certified.
certified, since in the earlier writ petition it was produced, I could not get it.
IA 1 of 25, ಅದಾಯ್ತಲ್ಲ, for the dispensed for the present, accordingly is disposed of. IA 2 of 25 is allowed and petitioner is dispensed with production of certified copy of annexure D and H in light of the submission that the certified copies were produced in the earlier round of litigation in WP number
00079 of 2025.
20079 of 2025.
Yes, learned GA to take notice for R1 to 6.
Yes.
Here, my lord, there is a recovery of amount of 40 lakhs rupees. my lords. I did not dispute the amount, my lord. I had only requested for some installments and one-time settlement. my lords. But in the similar matters, my lords, the coordinate benches have been giving this week, yesterday and all, my lords, 25% of the amount, total principal amount, my lords. And subject to that, stay was given and I would settle it in few installments with negotiation with DCC Bank, my lords. But the court, my lords, on the ground of alternative remedy has dismissed without noticing it, well and single judge. Here also, I would be making the request that, my lords,
You take notice,
Amresh Roja appears for the respondent one. my
all,
lords. Yes.
one.
1. 2 to 3, my lord, they are all the formal parties because guarantors that may be dispensed with, my lords.
Amrish Roja is right to accept notice for respondent number 1. Notice to respondents 2, 3 and 4. 2 and 3.
2 to 3,
2 and 3
2
is
and 3.
dispensed for the present.
present.
R4, GA is directed to accept notice for R4. You serve a copy.
Please.
List the matter on.
If it could be passed over, my lords. If the-
Pass over.
If the council, standing council is appearing and they are,
Merci. not
because in similar matters, my lords, I have been.
Merci. You demonstrate your bona fides, we'll see.
Please, sir, I have even pleaded that. I do not dispute the liability.
Single judge ಮುಂದೆ ಹೇಳಿದ್ರಾ?
My lords,
Single judge ಮುಂದೆ
I don't,
ಹೇಳಿದ್ರಾ?
I was not the council appearing there. Same thing. It was pleaded in the petition. I had only sought for a breathing time. That's
Clear for the petitioner, my lord. And
But in this case,
Yes.
I request your lordship have it on Monday, my lord, this matter.
ಯಾವ್ದು 17?
Yes, preliminary hearing matter.
Huh?
Penalty order was challenged before the tribunal, my lord.
the odd,
That was, my lord, set aside and, my lord, directed the authorities to provide the, my lord, monetary benefits. That's why I'm not doing.
2022 ಅಲ್ಲಿ KT order ಆಗಿದೆ. I gave number of representations.
So let's see, let him get ready. We'll take it up and dispose it on the
Dispose of.
file synopsis also.
Very short matter.
Hmm.
Very short matter.
Court has held that it's not proved. There's no.
The inquiry officer holds that the charge against the delinquent is proved. The Karnataka Administrative Tribunal holds that the complainant in this trap case has turned hostile, shadow witness has turned hostile, co-punch has turned hostile, everyone has turned hostile. So the question of the charge being proved doesn't arise. So they set aside the order. It is in 2022. I make a representation. In the year 2023, this particular application is filed. And they say that a matter is pending before the Honorable High Court. So after 10 dates of hearing, office objections are cleared.
Just wait. ಎಲ್ಲಿ Tuesday na Monday na ಯಾವತ್ತು?
Tuesday, your lordship.
Tuesday. Relist on Tuesday. Get ready.
Consider whatever, ಮುಗ್ದೋಗ್ತಿತ್ತು, so.
Documents record required, huh? Records of these.
But here, my lord, there is a, my lord, admitted fact, my lord.
Money proved.
Yes, yes. But even that money is recorded from him. That is, that is, my lord, finding is there before the tribunal. Still, my lord, is saying that it not proved. Demand and acceptance is not.
Produce, record produce money.
1 week after.
ಅದೇ Tuesday, Wednesday, ಯಾವತ್ತು ಬೇಕು? Thursday?
That's 23, my lord.
Thursday. Yes.
Your Lordship, I have heard the matter yesterday. Your Lordship directed to file the memo of calculation here with furnishing the memo of calculation. If I may pass on.
Calculation.
Please, Lordship, I will clarify. Lordship. Please, Lordship. Please.
ಅದನ್ನ ಕ್ರಾಸ್ ಚೆಕ್ ಮಾಡಬೇಕು.
Please, Lordship.
We sometimes blindly follow what you give.
No, Lordship, please.
Carefully. Recommend smaller. This miscellaneous first appeal filed against the judgment and award, judgment passed in MUC number 509 of 2015, dated 3/4/2018 by the second additional senior civil judge and MECT Kalaburagi, wherein the learned wherein the tribunal dismissed the claim petition filed by the claimant appellants. Full show. The parties are next parties are as per their ranking before the trial court. Number 3. Next one. The brief facts which are necessary for disposal of this appeal are that on 26/11/2014 at about 7:15 PM, near Sri Rangapur cross on Gulbarga Humnabad Road Highway, the husband of the appellant by name Murugaya alias Murugappa was standing by the left side of the road. At that time, a Hero motorcycle bearing registration number KA 32/EG3576 being driven by its driver in a rash and negligent manner and dashed to Murugaya alias Murugappa, full stop. In the result, he sustained head injury and other injuries on the vital parts of his body and became unconscious, full stop. Though he was shifted to Basaveshwara Hospital, Kalaburagi, and treated as inpatient from 26/11/2014 to 30/11/2014. However, he succumbed to the injuries on 30/11/2014, full stop. Thereafter, the jurisdictional police registered the case in crime case, in crime number 107 of 2014 against the driver of the offending vehicle, full stop. The, as such, the appellant claim it being the being the wife of deceased, has filed the claim petition before the tribunal, full stop, before the tribunal. Next, the tribunal on seeking compensation on account of the death of deceased Murugaya alias Murugappa in the road traffic accident. Full stop. Next, the respondent number 1 and 2 served. Respondent number 1 and 2 served, and however, respondent number 1 remained absent and has been placed in expert. Respondent number 2, the insurance company has filed the objection by denying the contents of the petition. Full stop. Next, and petition next. In order to prove the claim petition before the tribunal, before the tribunal, the petitioner, the claimant herself examined as PW1, so also got marked 8 documents as exhibit P1 to P8, full stop. P8 full stop. However, the insurance company has also examined its officer as RW1 and RW2, and also got marked 5 documents as exhibit R1 to R5, full stop. Next, the tribunal, after recording the evidence, hearing on both sides and on assessment of the oral and documentary evidence, dismissed the petition filed by the claimant appellant, full stop, appellant. They aggrieved by this judgment, judgment of the tribunal, this appeal, the appellant approached appellant. They said the judgment is challenged in this appeal, full stop. We have heard the learned counsel for the appellant and learned counsel for the respondent number 2 insurance company, full stop. It is the contention of the learned counsel for the appellant that the tribunal grossly erred while rejecting the claim petition in spite of placing sufficient materials before the tribunal. According to him, the accident is not in question, and also it is admitted fact that the deceased succumbed to the injuries sustained on the said road traffic accident, full stop. Apart from that, the jurisdictional police filed a FIR against the driver of the offending vehicle. So also after investigation laid the charge sheet against him. The said charge sheet was not challenged by the insurance company. In such circumstance, the tribunal ought not have dismissed the claim petition, full stop. Claim petition. Further, the tribunal has erred while dismissing the claim petition, that stating that the timings of the death of the deceased, timing of the admission of the injured to the hospital is not tallying with the medical records, full stop. Medical records. By relying on exhibit R1 to R3, he submits that the injured was admitted in the hospital after the accident at about 7 p.m. Accordingly, he prays to allow the petition by granting compensation, Full stop. Per contrast, the learned counsel for the insurance company would submit that, comma, the very accident in question, accident itself is doubtful, comma, the insurance company by perusal of the evidence of RW1 and RW2, comma, it is clear that the injured was not sustained injuries due to the road traffic accident, and as such there is a variation in the timings mentioned in the case register, in the case register as per exhibit R1 to R1 and R1 to R3, full stop. 1, 2, 3. Hence, in such circumstances, the tribunal is justified in rejecting the claim petition. Full stop. Petition. We have carefully gone through the evidence and material placed before us. Full stop. The points that would arise for our consideration is whether the tribunal is justified in rejecting the claim petition. And number two, the quantum. Number two, if not, what is the quantum of the compensation has to be awarded to the appellant claimant. Full stop. Claimant. It is not in next para. On perusal of records, comma, it could be seen the death of the deceased Murugaya alias Murugeppa in the road traffic road traffic accident is not much disputed, not seriously disputed by the respondent number two. It is the specific case that the said Murugaya admitted in the hospital on 26/11/2014 and was and admitted as a inpatient in the hospital till 30/11/2014 and he succumbed to the injuries. Full stop. Full stop. To that, to substantiate the said aspect, comma, the petitioner placed the postmortem report. So also postmortem report. Further, the police have also filed. Further, the jurisdiction police have also filed FIR against the driver of the offending vehicle, which covered with the insurance policy of the respondent number two in crime number 107 of 2014. After a detailed investigation, comma, the police have filed charge sheet in the said case. Full stop. Admittedly, the said charge sheet has not been been challenged by the insurance company. Full stop. Insurance company. In such circumstance, comma, the death of the deceased Murugappa in the road traffic accident cannot be is proved. Full stop. Is proved. Further is proved. On perusal of the impugned judgment award passed by the trial court, comma, it is the trial court has opined that the accident, the police papers reveals that the accident was occurred at about 7:15 p.m. But the injured was admitted to the hospital at about 5 p.m. on 26/11/2014. Full stop. As rightly, however, as rightly pointed out by the learned counsel for the appellant, on perusal of the case sheet, as per perusal of the MLC and case sheet, as per R1,
R1, comma, it is stated, the accident was caused at about 5 p.m. at about 5 p.m. and the injured was admitted in the hospital at about 7:42 p.m. 7:42 p.m. 7:42 p.m. Full stop. Though in exhibit R3, it is stated that the date of admission is on 26/11/2014 about 9:36 p.m. And discharge date on discharge on 30/11/2014 at about 2:15 p.m. That is after the death of deceased, comma, the said timings, the said timings only in respect of the admission of the injured in the injured in the ward. However, he was brought to the hospital. At about 7:42 p.m. as per exhibit R1. In such circumstance, it cannot be inferred that the accident the deceased was not died due to the accident. And the scene of accident and the timing of accident has totally manipulated by the claimant for a false claim, full stop, for a false claim for the false claim. With the above discussion, we are of the view that the tribunal has erred while dismissing the claim petition only on relying the variation in the time of admission of the injured to the hospital, by relying exhibit R3, full stop, R3. Hence, we answer the point number 1 in the error, madam. In the affirmative, in the negative, justified in the negative, full stop. As far as the full stop. As per the quantum of the full stop, the compensation to the climate is concerned, comma, it is stated that the deceased Murugappa was a farmer. Is a
LIC agent, your lordship. LIC agent is was
Farmer, his son is LIC agent, my lord.
is a farmer, so
Please.
also doing then
LIC agent.
also part and also engaged,
Please, your lordship.
part-timely engaged in a LIC
Please.
as a LIC
Please.
agent.
Please,
LIC agent. However, no such documents as placed by the petitioner to prove any income of the deceased, full stop. Income of the deceased. In such a circumstance, in the absence of proof of income, comma, the notional income of the deceased has to be taken, comma, full stop. Has to be taken. The notional income as per the chart provided by the Karnataka Legal Service Authority,
7,500, your lordship. I've given the
for
chart,
the
your
year
lordship.
2014,
your lordship.
2014 is rupees 7,500. 7,500. Hence, we hold the notional income of the deceased has to be taken at 7,500 per month. To the aforesaid amount, as the deceased was aged
60 years, your lordship.
60 years at the time of accident, comma, is to
10%, my lord.
10% future
10% has to be 10% of the said amount has to be added on account of future prospects.
Yes, my lord.
In view of the law laid down by the Constitution bench of the Supreme Court in Pranayaseti, full stop. thus the monthly income of ಎಷ್ಟು
8250, 8250, my lordship. 8250, my lordship.
8250 full shop. Since the deceased is ಎಷ್ಟು
60, my lordship. 9 multiplier will be applied, my lordship.
Multiplier will be 9 here, Lordship. In the calculation memo I have given.
The appropriate multiplier would be
9, please, Lordship.
hence ಅದನ್ನ ಹಾಕೊಳ್ತೀರಿ ಮೇಡಮ್, ಅದು ಲೆಕ್ಕ ಹಾಕೊಳ್ಳಿ. ಮತ್ತಿನ್ನೇನು ಇದಾಗ್ಬೇಕಾ?
Deduction 1/3.
Deduction is a how many this
1 here, Lordship. 1/3 has to be deducted.
full shop.
Only
is
one
a-
dependent,
The
my lord.
only the climate appellate
Wife.
is the only
Only one dependent.
Wife, my lord.
only
Wife.
defendant, only dependent, comma 1/3 has to be
Deducted.
deducted, which
Which comes
works
to
out is to
5,94,000 ಆಗುತ್ತೆ, my lordship.
5,94,000,
my lordship.
5,24,000.
94,000, my lord.
94,000.
Yes, my lord.
5,94,000. ಅದು ಇದು ಮಲ್ಟಿಪ್ಲೈಯರ್ ಆಸ್ ಪರ್ ಇದು ಹಾಕೊಳ್ಳಿ, ಆಸ್ ಪರ್ ಸರಳವರ್ಮ,
Yes, ma'am.
as per Saralvarma, full show. Next, further, in view of the law laid down by the Honorable Apex Court in Magma General Insurance Company Limited, comma, the appellant is entitled for a sum of rupees 44,000, 44,000
Please, Lordship.
towards the
40,000
towards loss of consortium, consortium. Consortium, hence on consortium, and also entitled to a sum of rupees 16,500 towards funeral expense and 16,500 under the head of
Other heads.
loss of estate.
Please, Lordship.
Loss of estate. Hakkoli madam. Thus in all the petitioner is entitled to a sum of rupees. Hakkoltare madam. So and so and so. Full show. Full show with the along with the interest at the rate of 6% per annum. Full show from the date of petition, from the date of petition till realization. In view of the above discussion, we proceed to accordingly. We answer point number 2 in partly in affirmative. In view of the above discussion, we proceed to pass the following order. The appeal is allowed in part. The
My lordship.
impugn judge.
One submission, my lordship. On 8/11/24, my lordship. While condoning delay condone, but interest for delay period is not granted, was not granted, my lord.
ಎಷ್ಟು ಬರುತ್ತೆ ಅದು? What is that period ನೋಡಿ ಮೇಡಮ್? ಅದರಲ್ಲಿ ತೆಗಿಬೇಕು, ಅಷ್ಟನ್ನು ತೆಗಿಬೇಕು. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನೀವೇ ಮತ್ತದು.
ನಾ ಮಧ್ಯಾಹ್ನ ತಂದು ಕೊಡ್ತೀನಿ.
ಹಾ?
Kindly grant time for ಒಂದ್ ಗಂಟೆ ತನಕ ತಂದು ಕೊಡ್ತೇನೆ, my lordship. ಡಿಲೇ ನೋಡ್ಕೊಂಡು.
ಅದನ್ನ ಆಯ್ತಾ ಡಿಲೇ ಮೈನಸ್ ಮಾಡಿ. ಡಿಲೇ ಪೀರಿಯಡ್ ಇಸ್ ನಾಟ್ ಎಂಟೆಡ್.
ಎಷ್ಟಾದ್ ನೋಡ್ರಿ ಮೇಡಮ್ ಡಿಲೇ.
ಅದನ್ನ ಹಾಕೊಳ್ಳಿ. This order or this court while order dated 8/11/2014 condoning the delay filing this appeal, condoning the delay of 207, condoning the 207 this appeal, ordered that the appellant are not entitled for the delay, entitled for interest in the delayed period. As such, ಅದನ್ನು ಮೈನಸ್ ಹಾಕೊಂಡು ಮಾಡ್ತೀವಿ. Full show. Next, the appeal is allowed in part ಅದೆಲ್ಲ ಆಯ್ತಲ್ಲ. The claimants are entitled for the compensation of rupees so and so and so.
Please.
With the interest ಅದನ್ನ ಅಷ್ಟು ಹಾಕೊಳ್ಳಿ. Next, the respond number 2 insurance company is directed to deposit the amount, deposit the compensation amount within before this court. Before this court.
Please.
Before this court within a period of 8 weeks. 8 weeks from the date of receipt of the certified copy of this judgment. This judgment. Yes, if such deposit, this amount is deposited, the same shall be released
Please,
to the appellant.
obliged.
ಕೊಡಿ. ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅದನ್ನು ಮಾಡ್ಕೊಳ್ಳಿ.
Ganesh Kalaburagi.
This is a suit for partition. This is the plaintiff's appeal, your lordship. Suit has been dismissed.
In this matter, TCRs may be required because I want to rely upon exhibit P7, which is an,
PCR to be summoned.
please, Your Lord. It may kindly be formally admitted, Your Lordship.
Appeal is admitted,
Obliged,
due course.
please,
Paper book to be filed within
8 weeks,
8 weeks.
please.
Yes.
Number 20. Abdul Muqtadir.
My lords, petitioner number 1 and 2 are minors, my lords. Minor children of Aruna and Dashrath, my lords. The father passes away in 2009, my lords. And the family partition was effected and registered in 2016, my lords.
What is the purpose?
My lords, for the benefit of the minors and their higher education, to sell the property in the favor of minors, my lords.
What are the properties? What are the children doing?
Agricultural land, my lords, measuring 5 acres, my lords, situated at Sharanu Sarki, my lords.
Where are the children studying?
Please, my lords.
Children are studying.
Please, my lords.
Where? What is the evidence produced that they're studying? PCR. Yeah. Huh? Let the TCR come, let's
Please,
examine.
my lords, one submission, my lords. Petitioner number 1 has turned major, my lords. He's studying his PUC, my lords. He has completed it.
So that stands discharged in so far petitioner number
1, my lords.
1.
Petitioner number 2, the case survives, my lords.
What's his age?
She's
What's her
15.
age?
She's 15 now, my lords.
15.
Please, my lords.
But you have not produced, marked any document relating to her education. In the evidence,
Please, my lords.
certificate, record of rights, Aadhaar, deed of partition.
We'll produce it, my lords.
Huh?
We'll produce it, my lords.
Produce it, let us see. You have
Please,
to
ma'am.
demonstrate
Please, my lords.
if you want to sell their share.
My lords, petitioner number 2 is not made party to the partition deed, my lords. Only petitioner number 1 was made party to the partition.
And
deed.
then why do you want to continue this proceeding? She has no share in that partition deed.
No, my lord, she was not made party, but she'll get her share through father's property, my lords.
Okay, let's say we get the TCR, we'll examine. You-
Please, ma'am.
Whatever other document you want to produce, you produce.
Please, my lords.
You produce certified copy. Why do we get TCR? 6 exhibits you produce.
Please, my lords.
The appellant is directed to produce certified copies of exhibit P1 to P6. And is at liberty to produce other documents in support of her contention regarding the education expenses of second petitioner.
Please, my lords.
This is the matter on week after next date. 13.
Oblige me, my lords.
Passed over to passed over to.
Pastor matters. Number 1.
Next, the admission, election.
Number 5. Till number 9. Shivashankar H. Manu.
my lords.
Just one. Yes. Good, fine. Give us that amendment.
Please.
Amendment.
I may be permitted to appear on behalf of Ganesh Kalaburagi, my lord.
Sure.
Amended rules, my lord.
Right.
There is it may be by typographical error, my lord, in the judgment. As per the rule, my lord, that is amended is, my lord, 49(1)B is amended, my lord.
Hello, 49(1).
One
Proviso.
Proviso. In the original Principal Act, there is no A, B, C, D, my lord.
Right.
In the amended provision, it is in subsection 1B is amended, second proviso.
ಅದು amendment ಅಲ್ಲಿ 1B ಅಂತ ಹಾಕಿದ್ದಾರೆ.
ಅವ್ರು 1B ಅಂತ ಬಂದಿದೆ.
So 49.
49 ದಲ್ಲಿ ಇದೆ. Third proviso, my lord. Earlier it was 2 year ಅಂತಿತ್ತು, ಈಗ 6 month ಮಾಡಿದ್ದಾರೆ.
Third provision.
Third proviso, my lord.
You read the third provision.
Yes, no.
Provided
Also that where a resolution expressing want of confidence in any Adhyaksha or Upadhyaksha has been considered and negativated by Gram Panchayat, a similar resolution in respect of the same Adhyaksha or Upadhyaksha shall not be given notice of or moved within 2 years from the date of the decision of the Gram Panchayat.
So that is the amendment.
That is the amendment is only respect of 2 years ಇದೆಯಲ್ಲ, my lord. That is now 6 month ಮಾಡಿದ್ದಾರೆ, my lord. So what happened if the no motion is moved, my lord, if it is considered and negativated, there are 2 words are used, my lord.
Then 6 months.
ಅಲ್ಲಿ 6 month ಅಂತಿದೆ.
Substituted within 2 years. Substituted within 2 years. Substituted for the words within 2 years.
ಅದು ಪ್ರೆಸೆಂಟ್ ಕೇಸಿಗೆ ಅಪ್ಲೈ ಆಗಲ್ಲ, my lord. ಅದು ಪ್ರೊವಿಷನ್ ನಮಗೆ.
ಹೌದು. Substituted for the words.
Now, correct. So
ಇಲ್ಲ, ಅದು ಇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಲ್ಲ, my lord. ಅಲ್ಲಿ ಪ್ರೊವಿಷನ್ 3 ಏನ್ ಹೇಳ್ತಾ ಇದೆ ಅಂದ್ರೆ considered and negativated.
Correct.
Here no consideration and no negative is there.
So that bar will not operate.
Bar does not apply, my lord.
Correct. So yeah, first writ appeal.
But what happened, my lord? Liberty is given by virtue of liberty. Again, they have made a same mistake and error. And that subsection of the law, the lila, my lord, B1 ಅಂತಿಲ್ಲ. ಅವ್ರು ತಮಗೆ ಹೇಗೆ ಬೇಕು ಹಾಗೆ ಮತ್ತೆ ಅದೇ ಮಾಡಿದಾರೆ ಅಂತ, that is my points.
No, correct. So your first writ appeal.
Yes, my lord.
Challenging the single judge's order.
Yes, my lord.
Does not survive.
Survive ಅಂತಂದ್ರೆ that is allowed, my lord. That my petition is allowed.
Correct. That proviso comes into operation only if it's put in the house and negative.
Yes, my lord.
Isn't it?
Yes.
So your challenge to that observation.
Yes, my lord.
By the single judge.
Yes,
saying without reference to the proviso.
Yes, my lord.
Technically will not arise.
Yes, my lord. In accordance with law, I agree, my lord. But second, what provision? Adana they have made a misuse anta nan point.
Correct.
Tomorrow it cannot be said already there is judgment, liberty is granted, therefore we moved anta anbardu annodekkaagi now we have filed a writ appeal.
That will clarify.
Yes, my lord.
That will clarify in
with
the first writ appeal.
Yes, my lord.
Because
And
in the
with
one
regard,
nimsha, one nimsha. In the first writ appeal, the learned single judge said, because there is some defect,
yes, my
they
lord.
set aside the whole proceedings
Okay.
and said you can do it afresh
Yes, my lord.
without reference to the proviso.
Yes, my lord.
Now, since it was not put into voting,
Yes.
technically the proviso did not operate,
Upright.
isn't it? So now they have initiated again.
Yes, my lord.
So in the second writ,
ಇಲ್ಲ ಇನ್ನು ಫಸ್ಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪಾಯಿಂಟ್ ಇದೆ my lord.
tell us.
The point for consideration ಇರೋದು page number 19 my lord. Page 19.
2000111.
Yes, my lord.
Page number.
Page number 19. The following para 8 my lord.
Yes.
Judgment para 8. Page number 19 my lord.
No, this is an extraction of some other order.
ಅದಲ್ಲ my lord. My lord, page 19 my lord. Page number 9 of the judgment.
Correct.
ಅಲ್ಲ para 8 my lord.
No, counsel.
Para 8 of the judgment.
One nimsha. This page, internal page 9 ಇದೆಯಲ್ಲ?
ಅಲ್ಲ 19, 19 my lord. Judgment page 9 my lord.
Correct. Judgment page 9 ಅಲ್ಲಿ, this is an extraction of WP 203171 of 24.
ಅಲ್ಲ ಈ ನಮ್ಮ ಕೇಸ್ ಬಗ್ಗೆ ಬಿ para 8 my lord.
Go to page 15.
The following point that arise for consideration.
Just one. Go to page, internal page 5 of that same order. Aita? In WP 203171 of 2024, wherein it is held as under.
WP 203487.
Correct, counsel. Page 5 of that order you go.
Rangan Gowda, N. Biradar and other.
No, I'm not, my lord, in the present, in the my writ petition, my lord, what was the point before the learned single judge, my lord? Please, my lord, may I read the para 8 of the judgment, my lord? Permit me to read the para 8, my lord.
Yes.
Para 8, the following point that arise for consideration in the present petition. This was the question before the learned single judge, my lord.
Which matter? In the previous, in some other.
Yes, in the present case itself, my lord, in the previous matter, my lord.
Correct. The same point comes in your case also.
This is my case, my lord. Para 8 is respect of my notice, my lord. Annexure B is dated 4/11/2024 is challenged, my lord, before the learned single judge. B and C challenged, my lord.
6, 7, 8, 9.
ಇಲ್ಲ para 8 ಇರೋದು ನಮ್ಮ ಕೇಸ್ ಬಗ್ಗೆ ಇದೆ, my lord.
Extraction till para 13, 15, till para 15. Till para 15.
The point for consideration is in respect of the present case, my lord.
No, in para 4,
Yes, my lord.
the single judge says, last line above, bold ಅಲ್ಲಿ ಇದೆಯಲ್ಲ, in
Yes.
the case of last three, Tangan Gowda.
Gowda, Biradar and others principal.
In
Yes.
so and so, wherein it is held as under ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದನ್ನ ಬಗ್ಗೆ ಡಿಸ್ಪ್ಯೂಟ್ ಇಲ್ಲ, my lord. Para 4 is right, my lord. ಆದ್ರೆ ನಾನು ಹೋಗ್ತಾ ಇರೋದು
ಅಲ್ಲಿ
para
ಎಲ್ಲಿವರೆಗೂ extraction
ಸಾರಿ para 6, 7, 8 ಅದು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮುಗಿತ್, my lord. ಅಲ್ಲಿಗೆ ಮುಗಿದಿದೆ.
ಎಲ್ಲಿಗೆ ಮುಗೀತು?
ಇದು 3 ಗೆ ಮುಗಿದಿ 2 ಗೆ ಮುಗೀತು, my lord. 2 ಗೆ ಮುಗೀತು. Para 3 present case start ಆಗುತ್ತೆ, my lord. On 4/11/2024, the respondent number 5 to 15 are.
That is in this matter.
That is in para 4, 3 ದಿಂದ ನಮ್ಮ ಮ್ಯಾಟರ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
What is my understanding correct?
My lord.
ಅಲ್ಲ ಏನ್ extraction ಎಲ್ಲಿ continue close ಆಗುತ್ತೆ?
The extraction, my lord, would my lord run.
Para 4 ನಲ್ಲಿ ಪಾಯಿಂಟ್ ನಂಬರ್ 1, 2 ಅಷ್ಟೇ ಕವರ್ ಆಗುತ್ತೆ, my lord. 3 ನಮ್ಮ ಕೇಸ್ ಇದೆ, my lord.
Till para 7, my lord. Para 6, sorry.
Para 6 ತನಕ ಕವರ್ ಆಗುತ್ತೆ. 7, 8 ಮತ್ತೆ ನಮ್ಮ ಕೇಸ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ, my lord.
It in fact, para 8 also would, my lord, is although the wordings are that the points for consideration in
Yes,
this petition.
The present case.
ಅದು ತೆಗ್ಸಿ ಅದು print out. Allah,
I
if
probably
this
have
is
it.
the way typing is done by the High Court, completely unacceptable. Let us see. Let us.
ಆಯ್ತು, ನಂಜನಗೌಡ ಇದು ರೆಫರ್ ಮಾಡಿದ್ದು, ರಿಟ್ನಾಗ ರೆಫರ್ ಮಾಡಿ.
Now you go to page, internal page 17. The court says, in view of the aforesaid facts, ಅಲ್ಲಿವರೆಗೂ extraction. That is our impression. Go to internal page 17 of the order.
17.
ಆಯ್ತಾ? Para 5 ಬನ್ನಿ.
Yes, madam.
In view of the aforesaid facts and circumstances. That is the only reasoning of the single judge.
Very, yes, madam.
Huh?
Yes, madam.
Then how is this your case?
It is squarely covered, very same, that.
Correct.
ಅದು ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗಿದೆ ಮಿಲಾರ್ಡ್. ಫಸ್ಟ್ ಜಜ್ಮೆಂಟ್ ಕೊಟ್ಟರು, ನಂತರ ನಮ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಬರ್ದು, ದೆನ್ ಪಾಯಿಂಟ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್ ಅಗೇನ್ ದ ಜಜ್ಮೆಂಟ್ ಇಸ್ ರೆಫರ್ಡ್ ಮಿಲಾರ್ಡ್.
ಆಯ್ತು, ಕಂಟಿನ್ಯೂ 5 ಆಗಿದೆ. 4 ಇದೆಯಲ್ಲ ಪ್ಯಾರಾ 4.
ಎಸ್.
ನೆಕ್ಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಪೇಜ್ 27 ಅಲ್ಲಿ ಪ್ಯಾರಾ 5.
So they adopted it ipso facto.
Yeah.
Without reference to the facts, some legal position has been followed.
Yes.
So what is your contention now?
My ಮಿಲಾರ್ಡ್, ಮೇ ಐ ರೀಡ್ ಪ್ಯಾರಾ 4 ದಲ್ಲಿ 8.8 ಇದೆ ಮೇಡಮ್. ಪೇಜ್ ನಂಬರ್ 9 ಆಫ್ ದ ಜಜ್ಮೆಂಟ್.
ಆಯ್ತು ಹೇಳಿ.
Page number 9 of the judgment 8 ಅಂತಿದೆ ಮಿಲಾರ್ಡ್.
Hmm.
That is my case. Not the following point that arise for consideration in the present petition. The present petition ಅಂತ ಬಂದಿದೆ ಮಿಲಾರ್ಡ್. ಅದರಲ್ಲಿ whether the impugned complaint at annexure B dated 4/11/2024 submitted by the impugned applicants to the respondent number 3 assistant commissioner in form number 1 under rule 3(1) of the said rules, as well as the impugned notice at annexure E1 dated 14/11/2024 issued by the respondent number 3 in form number 2 under rule 3(2) of the said rules of 1994 are legal, valid and proper and in conformity with the rule 3 of the said rules 1994. So there are 2 points, my lord, annexure B and annexure C.
This order in WP 203171 of 24.
Yes, ma'am.
This extract is the extraction in WP 203171 of 24.
Yes.
This single judge has copy pasted the observation parity. The finding in that writ petition, if is not challenged, here in this writ petition, since.
Yeah, I agree, my lord. The findings, I'm not disputing it, is in my favor, my lord. The court said the rule 3 must strictly followed.
Correct.
So, and learned single judge also given the formats of rule 3(1) also referred, my lord.
Yes.
Court ಏನ್ ಹೇಳುತ್ತೆ, format also must be strictly followed. ಅಲ್ಲಿ ರೂಲ್ 3 ಫಾರ್ಮ್ ನಂಬರ್ 1, ಫಾರ್ಮ್ ನಂಬರ್ 2 ಎರಡು ಬರ್ತಾವ ಮಿಲಾರ್ಡ್. ರೂಲ್ 3(1) ದಲ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ 1 ಬರುತ್ತೆ, ರೂಲ್ 3(2) ದಲ್ಲಿ ಫಾರ್ಮ್ ನಂಬರ್ 2 ಬರುತ್ತೆ ಮಿಲಾರ್ಡ್.
ಆಯ್ತು.
ಎರಡು ಫಾರ್ಮೆಟ್ ಸ್ಟ್ರಿಕ್ಟ್ಲಿ ಫಾಲೋ ಮಾಡಬೇಕು. ಫಸ್ಟ್ ಫಾರ್ಮ್ ನಂಬರ್ 1 ಏನಿದೆ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ಲಾ ಇಲ್ಲ ಅಂತ ಸೆಟ್ ಮಾಡಿದ್ದಾರೆ ಮಿಲಾರ್ಡ್. ಸೊ ಫಾರ್ ಫಾರ್ಮ್ ನಂಬರ್ ಸೇ ಬಗ್ಗೆ ಕ್ವಶನ್ ರೈಸ್ ಮಾಡಿದ್ರು, ಬಟ್ ಅದನ್ನ ಆನ್ಸರ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ಫಾರ್ಮ್ ನಂಬರ್ 1 ತಪ್ಪಿದೆ ಅಂದ್ಮೇಲೆ ಕನ್ಸಿಕ್ವೆಂಟ್ ನೋಟಿಸ್ ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು. ಇನ್ ದ ಪ್ರೆಸೆಂಟ್ ರಿಟ್ ಪಿಟಿಷನ್ ಐ ಆಮ್ ಚಾಲೆಂಜಿಂಗ್.
So why you have challenged this?
My milord, liberty is given by virtue of the liberty. They done the same things.
That
Tomorrow it cannot be said that already there is a finding. It cannot be affected to the present writ petition, milord. So again, they have made a same mistake. Form number 1, form number 2 also committed the same mistake and not acted according to the law, milord. Section 49 is not followed. Rule 3(1)(2)(3) is not followed, and form 1 and 2 is not followed in the present writ petition. This is my argument in the present case, milord.
Previous round, the court says that fresh representation in
Yes.
form 1 is to be given. Form 1 says it must be given to the DC,
Assistant Commissioner.
Assistant Commissioner.
Milord, page 17 of the judgment, milord. Otherly, liberty is reserved in favor of the respondent number 5 to 15 to submit a fresh new representation to the respondent number 3 assistant commissioner in accordance with law and strictly in compliance with rule 3(1) read with form number 1 of the Karnataka Panchayat Raj and no motion against Adhyaksha and Upadhyaksha of Gram Panchayat rules. And second direction is issued to the assistant commissioner, milord, para 5 of the judgment. In the event of such representation is submitted by the respondent number 5 to 15 to the respondent number 3 assistant commissioner as stated supra, the respondent number 3 assistant commissioner shall issue the same
and proceed further in accordance with law. I am agree, my lord, he has to follow accordance with law. Further, again, 49 apply agala adu ada, they have made committed misuse, adu barbadanta, that is my present writ appeal alli iru grievance, my lord. Adu adanna misuse madidare anta andre they have to follow rule 1, rule 3, 1, 2, 3 and form 1, form 2 and section 49. Whether the present writ petition, my lord, in the second appeal, my lord, whether the respondents have acted as per the law or not, my lord, whether 49 is clearly applied or not, and rule 3, rule 1 and 2, rule 3, 1, 2, 3, my lord, and form number 1 and form number 2.
We'll do one thing.
Yes.
Now, the single judge's order is not yet released. Single judge's order is not yet released. We will say whatever takes place pursuant to the impugned proceedings would be subject to the outcome of the writ appeal. We'll put them on notice. Let it go ahead. We will call it next week. Let the order come. We will see. If we were to accept your contention, we'll set it aside. We'll make it clear that whatever takes place would be subject to the outcome of orders to be passed.
But my lord, ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ, ಈ ತರ ಆರ್ಡರ್ ತಗೊಂಡ ನಂತರ ಅವ್ರು ಹರಿಡ್ಲಿ ವಾಟ್ ಹ್ಯಾಪನ್, ಮತ್ತೆ ಇದು ನೋ ಮೋಷನ್ ಮಾಡ್ತಾರೆ, ರಿಟ್ ಪಿಟಿಷನ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೋತಾರೆ, ಅಲ್ಲಿ ಮತ್ತೆ ಇಲೆಕ್ಷನ್ ಮಾಡಿದ್ರೆ ಇನ್ಫ್ಲೆಕ್ಚುಯಸ್ ಆಗುತ್ತೆ. Apart from that order, my lord, election may not be done till disposal of this petition.
No. Until we see the order of the single judge and we find there's an error, we cannot pass such order. We'll make it clear that any election, no confidence motion, whatever happens, would be subject to the outcome of these proceedings. Let us see what happens on the
I agree, my lord. What happens in the
We'll have it on
situation, my lord?
Wednesday.
What happens in that circumstance?
That will come to that then. If now, after no confidence, they have to again hold election, all that process will take at least a month. By then, the single judge's order will come, we'll take note of it. Let us-
Till further order, election may not be done ಅಂತ
No,
ಅದೊಂದು
no, no.
ಸೆಂಟೆನ್ಸ್ ಆದ್ರೂ ಬರ್ಬೇಕು. Otherwise, infectious ಆಗುತ್ತೆ, my lord.
We will assure you, I will keep it open that it will not be rendered infractions. The counsel for the appellate challenge the order of the learned single judge and submits that the and has raised several contentions, including that the procedure under rule 3(2).
3(1).
Rule 3, 1, 2 and 3 is not followed.
Rule 3, 1,
3, 1, 3, 2 and 3,
3, 1,
3, 1,
2 and 3
3 is not properly followed.
is not adhered
Not
to.
And the formats are not strictly in accordance with form number 1 and 2, my lord.
And complaint made to the assistant commissioner is not in form 1 and form 2.
2.
Full stop. The said contentions were advanced before the learned single judge, who has however rejected the petition. Full stop. Next.
And my
It is
lord,
noticed that
it is also not in accordance with section 49. my lord. Entire
full stop. The present appeal is filed against order of the learned single judge. Full stop. However, the order of the learned single judge has not yet been released. In the interregnum, any action taken by the respondent number 3, to hold the meeting to consider. No, who's going to hold the meeting? Three, any action taken by respondent number 3 to hold the meeting to consider the motion of no confidence and subsequent proceedings would be subject to orders to be passed in the present proceedings. Accordingly, though we do not prohibit proceedings of no confidence to be conducted on 18th.
18th.
We make it clear that the legal contentions that have been raised are still under consideration in the present writ appeal. Relist the matter. We'll have it on Thursday. Thursday.
Please.
23rd. Please. If any proceedings are held on 18th, necessary report to be filed. Please.
My lord, the third expert may be directed to produce the records, my lord, with regard to the present case, my lord.
Operative portion may be brought.
ಹಂಗಲ್ಲ
It
may be applicable to
the Assistant Commissioner, Government Advocate is to secure records relating to the complaint filed, notice issued, etc. by the next date.
My lord, this ಎರಡು ಕೇಸಿಗೂ apply. My lord, in respect of both cases, order same order in respect of.
Just wait. Now, we are not prohibiting you from doing it. You have to give a report. Meanwhile, whatever records for the purpose of appreciating his contention, you give. So it doesn't mean we have stopped. That's clear?
Please.
It is applicable to both cases.
Common order.
Common order.
Number 10, Anant Jahagirda.
Both appellate number 1 and 2 are died. Your there is a number I1 of 24 is there to bring the legal representatives of appellate number 2.
IA1 of
24.
uh,
Along with wakalat and applications I have filed.
that has to be allowed.
That is one first aspect, it is to be
It
allowed.
has been filed within time.
It is within time.
IA1 of 24 has been filed by the legal Illa, the 2 is there.
Appellate number 2. Yes.
That has to be allowed.
That is.
Then
Copy
you
to other
come-
side is served to you.
No, correct. So you will come as appellant number 2 A to F.
Yes.
Isn't it?
Yes.
IA number 1 of 24 has been filed by the legal representatives of the appellant number 2 to come on record and represent his interest. As it is submitted that appellant number 2 died during the pendency of the present proceedings.
Yes.
Hmm.
23/5/24.
In light of the amendments made in the affidavit, application is allowed. The proposed applicants who are the children and
Son, husband and children of the
the husband and children of the deceased are permitted to come on record and represent interest of deceased appellant number 2. Necessary amendment to be carried out. You have filed your wakalat also.
Yes, yes, sir.
Okay, now what about appellant number?
Appellate number 1.
Ah.
IA1 is for condonation of delay,
IA1 of
23.
23.
And IA number 2 is for setting aside abatement. And I number 3 is for to bring the LRs of appellate number 1 on record as respond number 8 and 9.
IA3.
Yes.
As respondent number 8 and 9.
Yes, yes. Yes.
They have filed,
The notice were served, remained absent.
they have remained absent. It is further submitted that appellant number 1 died during the pendency of the proceedings on
Yes.
23/9/2022. And the applicants and the legal representatives of the said appellant number 1 are sought to be brought on record. Accordingly, IA1 of 23 has been filed, seeking condonation of delay of 185 days in filing application to bring LRs of deceased appellant number 1 on record. IA2 of 23 has been filed, seeking to set aside abatement, and 3 of 23 has been filed, seeking to bring the legal representatives of deceased appellant number 1 on record as proposed respondent 8 and 9.
9.
Full stop. Is notice that notice was issued on the said IAs and the proposed legal representatives of appellant number 1 have been served. Full stop. In light of the amendments made, IA1 of 23 is allowed. Delay in filing application to bring LRs on record is condoned. IA2 of 23 is allowed. Abatement is set aside. IA3 of 23 is allowed. And the legal representatives of appellant number 1 are permitted to come on record and represent the interest of the deceased appellant number 1 as respondent 8 and 9. That's the amendment to be carried out.
What?
Yes.
On the date may kindly be fixed your
Relist on.
20. Do we have it on next week or is it first week?
First week would be.
5th. Much.
Till number 60. Hema helpful current.
Time for the first respondent.
Now they only want a request for payment on installment. Find out.
Please, my lords. The
You appear for the
bank, my lords.
bank. You find out.
Please, my lords. I will find out, my lords. Kindly see the prayer in the writ petition, which is passed by the page 23, my lords. The award passed under section 71 of Cooperative Societies Act is called in question, my lords.
Without filing appeal.
Lords, alternative remedy is the one ground, my lords. Even the district registrar or joint registrar is not made a party who passed an order.
In case they're going to pay, suppose they're going to pay.
I am told that, my lords, 3 months time, my lords, if appellant files an affidavit, my lords, with equal installments.
3 months.
Find out.
Yes.
List on.
Anything.
Because attachment order is issued. Because recovery and attachment orders are issued.
Correct, madam. Tomorrow you file affidavit, we'll close it. When you want, you tell us, you get instructions and you tell us, there it's the matter.
3 months would be too short in a time.
That you talk to him
Please.
in the meanwhile and you work out some settlement. Some reasonable, little more extension, he may be ready.
25% at the first installment, I'll pay minutes. 40 lakhs is there, I'll pay, and another 3 installments, I can clear it off.
That you give it to him, let him put across.
Please.
When will we have it?
Monday.
Monday. Meanwhile, you give, let him find out.
Please.
Please.
We'll list on Monday.
Obliged.
Notice order Monday.
On matter, my lord. Serial number 1.
Serial number?
My lord, in this, my lord, I have challenged, my lord, the annexure. Annexure K, my lord, ink page 140. The petitioner has been selected, appointed, my lord, selected as assistant professor for Urdu, my lord. His name was appeared in provisional selection list. And the said selection list was, my lord, notified in the official gazette. Thereafter, abruptly, my lord, without any notice, my name has been removed.
Where is the result selection list? Page?
Lord, ink page, my lord, selection list is ink page 113, my lord. 133. My name is at.
Just one minute. Yes.
Ink page 133, my lord.
That is the list.
List, my lord. Provisional selection list, wherein at serial number 2, Syed Asadullah, my name is
Syed Asadullah.
Subsequently.
Just one minute. Revised provisional selection list.
Yes, my lord.
Where is the final list now?
No, Lord. Subsequently, annexure H1. H1 is the notification where it is notified my name. Notification.
Page,
page 135. This is the gazette notification wherein my name was published. That is it's a final.
where is your name?
My name is in
Syed
page
Asadullah.
136.
Okay.
Syed Asadullah.
Under Kalyana Karnataka category.
Yes, ma'am.
Urdu.
Yes.
Huh?
Yes.
Okay. Now what has happened?
Now thereafter ink page 140, my lord.
Now this final selection list was on what date?
My lord, it is-
11/23.
Yes, my lord.
Then what happened?
Then ink page 140, my lord.
Ah,
The Karnataka Examination Authority has published one more revised selection list. Where one my lord,
Meher Jabin
Mahjabin.
in your place.
No, not my place. No. Her name was, she was already appointed. Her name was kept in operation for order portion, my lord. I will need notice there, my lord.
Hmm.
I will read out the note.
Read out.
As per the directions of the government, it is letter dated 22/11/2022 to the effect that in case eligible candidates under SC and ST category are not available, those posts to be filled up by the general merit candidates, and accordingly Miraj Ahmad and Syed Asadullah were selected at serial number 1 and 2 in the Kalyan Karnataka cadre final selection list dated 3/3/2010. But in view of the final judgment in application number 5802 of 22 of the Honorable KSAT dated 11/9/2023, the above said two candidates are removed from the final selection list dated 3/3/2023, and only serial number 3 of the final selection list dated 3/3/2023 by name Mahjabin selected under category 1 Kalyan Karnataka will remain. So along with me, one more person's name has been deleted.
So we don't know what has happened in the KT application.
But Lord, I have filed that the order is produced at ink page 114. It is filed by one Ms. Sudha Rani. Sudha Rani English.
Okay, now you take out notice. Let us see what the government says.
Lord, this no way concerned. Your Lordship may kindly see.
Let us see. We'll give you relief. But let us just, you're saying that application order,
Yes,
KT does not relate to this post.
yes, yes. And she has not challenged my post. Neither she has challenged the final notification, not provisional.
Correct. We'll ask the government to clarify.
Till then, my lord, we may be, my lord, select, because other candidates have been selected on the orders of the High Court, my lord, interim orders.
So let us
Because
see.
till the pendency, let they issue the order, my lord.
That we can't, but we'll hear them and see what is to be done. We'll hear them, let him get instruction. You find out. Now, after that selection list in 23,
Yes.
till date, they didn't give you appointment order.
No,
Let us see.
no, they have not given.
Let us.
On the
AG
basis of
accepts-
KT order, my lord, they say that your name has been deleted.
What is the KT? What is the finding of the KT?
KT, my lord, your lordship,
Page?
ink page 114. There they have sought for mandamus. The relief was,
You are not a party in that.
no, I was not. They have not challenged whatever, they have not challenged the process itself, my lord. What they say that because her name was not been called in the for
No, but however you file the writ here directly before the division bench.
my lord,
You are challenging which order before the division bench?
both the orders, my lord, because
Orders
that
of-
is orders of examination authority as well as KT, because
KT also.
because it's consequential. What the relying on the orders of KT, my lord, they have removed my name. So that order has
Okay,
to,
let us.
therefore I have made that.
He accepts notice for respondent 1 and 2. 1 and 2. What about examination authority, any standing counsel?
Basuraj,
Basuraj?
Basuraj Mat.
Basuraj Mat. For respondent 3 and 4. Emergent notice to respondent number 5. List the matter week after next date
My lord, no, my lord, I will take hand summons.
of the petitioners also at liberty to take out notice by way of hand summons to the private respondent.
Bro, next week, any date, my lord, I will secure her.
24th,
Lord,
24th, you find out.
23, my lord,
Huh?
23.
23. You find out. But we have to hear the government, we'll see what is to be.
Because it has no bearing at all, my lord. Nothing is there in that KT order.
What is the KT's order? What is the KT's order?
KT's order, my lord, lordship may kindly see. They, with regard to, because after final selection list, nothing is remained to consider. After what they say, my lord, the direction of to the first respondent dated so and so as stated in the replaced statement of third respondent is malified in nature and vitiate the selection process of assistant professor. Therefore, any selection made for the post of assistant professor, which is only based on the.
Just 1 minute, just one.
Please.
Now you are under which category, your selection?
HK, my lord. HK region.
Hyderabad, Karnataka.
Karnataka.
ಅದರಲ್ಲಿ ಸೆಪರೇಟ್ ಏನಾದ್ರು ಇದೆಯಾ? GM, ST woman.
GM.
GM.
Because no SC candidate is available, therefore GM. Because no, they have not challenged the final, neither provisional selection list nor final selection list. Yes.
When was the KT order passed?
Not KT order is passed on 11th September 2023.
Why you came so late?
Not because it was not in my knowledge, because I was not made a party. Only after my name has been deleted, I came to know.
No, correct. Now.
Thereafter, we have given representation after representation.
Have they given any appointment to that respondent? Appointment order in the issue? That Sudharani Ingale.
ಇಲ್ಲ ಅವ್ರು ಏನು ಕೇಳಿಲ್ಲ ಅವ್ರಿಗೆ ಯಾಕಂದ್ರೆ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರ ಸೆಲೆಕ್ಷನ್ ಪ್ರೋಸೆಸ್ ರೀಸ್ಟಾರ್ಟ್ ಮಾಡ್ರಿ ಅಂತಾರೆ. ಈಗ ಆಲ್ರೆಡಿ ಸೆಲೆಕ್ಷನ್ ಪ್ರೋಸೆಸ್ ಇಸ್ ಓವರ್ ಅಂಡ್ ವಿ ಹ್ಯಾವ್ ಬಿನ್ ಅಪಾಯಿಂಟೆಡ್. the KT order is of no consequence.
Revised selection list ಪ್ರಕಾರ ಅವರಿಗೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಕೊಟ್ರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ she has filed an application. Her name has not been called for the paper verification. Again, appointed Agila, she is no way.
No, we'll say one thing, otherwise it may create problem. We'll say no further steps pursuant to the order of the KT.
But till today, my lord, nothing is happened, my lord. After passing the order, kindly see my lord, page number 123, my lord, para 10. Why, my lord, that was disturbed, my lord, for that is the reason. Para 10. 123 page number, my lord. This tribunal at a hearing on 21/12/2022 observed at the pleading of the applicant's counsel that the posts which are for different reservation categories, only one of for the GM category, are sought to be filled by 3 GM candidates. And in order to accord any interim order, the factual clarification is necessary from the examination authority. It is undisputed that prima facie, the contention of the applicant has bearing on the preparation of the selection list itself with regard to the reservation category for which selection is made. And without providing the same, it cannot be said that the respondent authorities can proceed with the preparation of the selection list, and the preparation of any such selection list is always subject to the decision of the case. The respondent state and the third respondent, by delaying education in the case by repeated and consistent adjournment, cannot vitiate the decision of the case by claiming that the application has become infructuous when the adjournment were entirely due to the respondent. In the circumstances, we are the considered view that the applicant has been forced into this litigation by the action of the respondent state, which have vitiated the selection process by direction 22/11/2022, which is the nature of interfering with the lawful authority of the examination authority. Third respondent and the which direction has no base under law after the recruitment process has commenced and is at the state and declaration of result of the selection process. The applicant is thus entitled to the cost of rupees also that is imposed, my lord, thereafter, my lord. Para 12. Ordinarily, we would not have interfered with the process of selection.
No, but we have one, now his selection list, if KT is setting aside, must not be heard.
We don't know, my lord, what happened, my lord. Till, my lord, you will also have 22nd, my lord, we'll get to the correct position, my lord, what happened, my lord.
My lord.
On 22nd, in the interregnum, any action taken pursuant to the order of the KT would be subject to orders to be passed by this court.
Please.
But you find out, now if that selection list is being set aside, must you not intimate him? He is not a party in that writ petition also. That lady's category is different. SC woman.
Please.
She is GM.
And she has not been selected.
Uh,
Her name was even not in the list, my lord. Her name has not been called for the document verification. She has filed writ petition seeking mandamus. When the process itself is completed, that mandamus is not going to bear any effect on the. Yes.
Office objection is there, my lord.
Lord, I will comply meantime.
Be complied by the next.
Please.
List on 22nd. Find out. Before any third party rights are created.
Please.
Meanwhile, you find out that whether any appointment order is.
No. I have, my client is there here only.
That is.
There is no threat, my lord, that's why.
No.
If the appointment order is not issued, my lord, there is no threat.
No, not threat. my lord. Because
Hello, no done. Let us see.
our name.
Yes.
Number 5. Ramachandra.
Not serial number 21.
Number 5.
Well, now gone through the affidavit filed by the respondent number 4 and 3, my lord. They have not issued any endorsement. They have not complied with the order of single judge. Simply filed memo and.
Busare. Kursi. You call that Busare? Auretane?
Yes.
Prashar.
Huh?
Prashar.
Kursi. Pass over. Phone mat Kursi.
Please.
Idre Kursi. Yes.
21. Mahesh Patil.
Not appearing behalf of the petitioner.
Twenty-one.
Please. My lord, this matter, my lord, in the last occasion, my lord heard the matter, my lord, and directed me to file the synopsis along with one decision, which is where I have, this is the matter, my lord, where the petitioner was exonerated from the Lokaयुcta itself is given the report that, my lord, there is no charges has been proved against him. Subsequently, one more order has been issued by the government saying that inquiry has to be conducted as a fresh. So to that, he is retired, my lord, and the criminal case is also over and he is acquitted in the criminal case also. My lord's directed to produce on judgment which is collected by the Satish and I have produced along with synopsis.
What is the judgment say? Let us say. That's
Yes,
you can't order for re-inquiry.
yes, my lord.
Let us
Disagreement that, my lord, that is in document number 31. Document number 1 I have produced, that is acquittal of the criminal case of the petitioner.
No, which is the judgment you said you have
No,
produced?
22406 of 2024. Decided on 6th November 2024. I filed the synopsis on 15th, I think.
I think it
15.
is not, I think it is not put up. Didn't put up. Synopsis with judgments filed on 15 January.
Yes, yes, ma'am.
In that you have produced this order.
Yes, my lord, I have produced it. One judgment is that, my lord, the lower court decision, that is, he is acquitted, first judgment. The second judgment, which starts from the page number 31, that is similar view taken in the
Which
lordship.
paragraph? Which paragraph? Which paragraph?
My lord, the paragraph from the 5.
Yes.
Sorry, my lord, paragraph number 4.
Yes.
Clearly, once the inquiry report is placed before the disciplinary authority, where the disciplinary authority itself is not inquiring authority for reasons to be recorded by its writing, remit the matter back to the inquiring authority for further inquiry and to submit the report thereafter. Here is the same thing has happened, my lord. In terms of Rule 96F of the disciplinary authority, when it disagrees with the findings of the inquiry authority on an article of charges, is required to be recorded reasons for such disagreement and record its own findings regarding the same. In terms of Rule 96F2, the opportunity of hearing is also provided for the observations made in the Apex Code Punjab National Bank so and so in paragraph number 17, my lord. That is extracted, my lord. Thereafter, my lord, the matter is remitted to the in para 7 stage of disciplinary authority. Considering the report of the inquiry report, all contentions are kept open. The respondent is liberty to follow the appropriate procedure of 96F1. And the basis of the inquiry report, my lord, consequential settling the pensionary benefits to the petitioner.
So you are saying if the disciplinary authority is going to record a finding contrary to
Yes,
the
yes.
inquiring authority, then the employee delinquent must be heard. That
Yes,
has not been done. That is your
that is
contention.
also not done. Even the criminal case he is acquitted, that is also not considered.
No, that means. Okay, then have a look at it.
Please, my lord, it can be reserved.
So we'll have it on Tuesday. We'll have it on Tuesday.
Please.
Relist on Tuesday.
Please.
RJ Busar held up in KTML. ಹೆಂಗ್ ಮಾಡೋದು ವಾರಂಟ್ ಇಶ್ಯೂ ಮಾಡೋದು ಹೆಂಗೆ ಮಲ್ಲಿಕಾರ್ಜುನ್
Bailable warrant may be issued, because my lord's officer should not be.
ನೀವ್ ಹೇಳಿದ ಮೇಲೆ ಮಾಡಿ
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ
No, they must show, isn't it? Some seriousness.
last occasion also, my lord, your lordship given the.
Present proceedings have been filed. Seeking for initiation of contempt proceedings against the respondent accused in light of the direction granted in WP 203208 of 22, wherein the executive engineer RDPRE project division was directed to consider representation submitted by the complainant petitioner dated 6/11/2022 and pass appropriate orders. In such proceedings, the said official has been arraigned as respondent accused number 3. Yes. An affidavit is stated to have been filed by accused number 3 in one set.
Yes. Actually, accused number 4 filed that affidavit and memo, which was adopted by respondent number 3.
Well, that means, now here,
Yes, one set they have filed.
affidavit is filed by whom?
Respondent number 4 only, which is adopted by respondent number 3 later.
The respondent number 3 has filed a memo adopting the affidavit filed by respondent number 4.
Yes.
The respondent number 4 has filed an affidavit only in single set. There is no representation on behalf of respondent number accused number 4 or respondent accused number 3 when the matter is called out. 3 and 4, nobody is appearing. ಬಂದಿದ್ರಾ ಬೆಳಿಗ್ಗೆ ಯಾರಾದ್ರೂ ಇಲ್ಲ?
Nobody is.
3 and 4, no. But they have counsel ಇದ್ದಾರೆ.
Chandrasekhar Dasan is used to practice in trial court melody.
ಇಲ್ಲ ಆಯ್ತು, ಅದು 3 ಗ 4 ಗ ಅವರು.
3.
4 ಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ?
4 is not, nobody is represented, my lord. But he filed the affidavit of the respondent 4 along with memo
Yes.
by the respondent 3. I don't know how without serving notice to him.
Four ಗೆ counsel ಇಲ್ಲ. Then how was the affidavit filed by
Yes,
4?
so I-
Papis also not served other side and me. Government.
It is notice. ಯಾರು affidavit ಯಾರು filed ಮಾಡಿದ್ರು?
Only R3 my lord will ask me issue, my lord, because R4 is my lord, notice is not yet issued. Only R3 my lord, he filed the memo.
The counsel for R3 has not appeared. If R3 relies on the affidavit of R4, R3 is required to represent before this court and make necessary submissions by placing reliance on the affidavit of R4. In light of absence of representation on behalf of R3, issue bailable warrant to R3 for sum of 25,000 to be executed by the jurisdictional SHO. Relist on date code 4th of February.
Please. My lord, I will also try out on Wednesday, my lord.
I am for respondents, my lord.
Wednesday, you lords.
My lords have heard it. Lords have heard it. Kindly peruse the order sheet dated 5/9.
My lord, here, my lord,
5/9.
we not appointed the my lord respondents hearing. Thereafter, my lord, this all court directed us to appoint these persons because they are the eligible. Thereafter, my lord, we appointed the respondents and given the posting also, my lord, paying the salary also. They are all the duty. But question is before last week, my lord, whether, my lord, 3 years course is completed by the other candidates is eligible to the appointment of the as per the notice.
Read that order of 5/9/24. Let us have.
5/9/24.
Read that order.
Please.
Read the order. Read the order.
Lord, the applicants contend that the qualification as per the recruitment notification is SSLC along with the 3.5 years of diploma in nursing. It is, however, the case of the applicants that the respondent has recruited those who had only 3 years diploma course in violation of the recruitment notification. The said aspect of the recruitment of those who have obtained 3 years diploma course contrary to the recruitment notification has not been rebutted, as is the finding in the order of the tribunal. Further, the tribunal, while relying on the order passed in application numbers 701 to 705 of 2010, has reiterated that the qualification cannot be relaxed contrary to the recruitment notification. Read it the matter for stand of the state on 18/9/2024.
Now you have completed 3.5 years.
My lord,
You have completed 3.5 years.
Yes, my lord. Yes, my lord. Kindly see my rejoinder.
No. So now, what is the main matter? They are seeking for
But his selection was rejected, my lord.
his selection was
Yes,
rejected.
then he challenged before the my lord KT.
KT.
His
47.
contention is that, my lord, I completed 3.5 years course.
Huh.
But by authorities appointed the my lord who has completed 3 years course.
No, correct, sir. Now
Then, my lord, tribunal directed us to appoint these all the my lord respondents. Then we challenge that order, my lord. For this reason, my lord, we appoint, because my lord, there is a number of posts are there, but candidates is not available. 3.5 years course, my lord, only few candidates are there.
Page number 11.
you are the respondents, you are the applicants before the.
We were applicants before the KT, and he had challenged the order of the KT before this honorable.
They have challenged.
Order is in our favor. KT order is in our favor.
So what was the direction before the KT?
KT has directed the respondents to give us appointment order because there is a change in the midst of the recruitment process.
Just one. So now operative portion at page 62, just read the operative portion of the KT order. Page 62.
Yes, ma'am.
You read from page 61, para 7.
The states
Para 6, para 6.
states writ petition, my lord.
No. Page 60, para 6 of the order of the tribunal.
We have heard the learned council. There are 6.
Huh?
6 of the judgment. 6 of the judgment.
Yes, ma'am. Lord, we have considered the rival contention of the and perused the
There are 6.
Huh?
There are 6 of the KT order.
KT order only I am reading.
We have heard the learned counsel on both sides.
My lord. We have heard the learned counsels on both sides and also perused the applications and the annexures attached to it and the reply statement of the respondent state. In the reply statement, there is no denial of the contention of the applicants that large number of persons who do not have the prescribed and requisite 3.5 years diploma in nursing qualification have been selected. It is pertinent to mention that candidates who had only 3 years diploma in nursing qualification are ab initio ineligible for being selected, notwithstanding that they may have secured higher average marks of the SLC and the eligible 3-year diploma in nursing marks taken together than the average marks secured by those who had SSLC and 3.5 years diploma in nursing qualification.
Just one.
In view of the discussion.
Now you read further.
In view of the discussions above, we are of the considered view that the impugned endorsements dated 35/2018 as at annexure A2 to A5 are untenable since they are not at all in compliance with the judgment of this tribunal in application number 701 to 705 of 2010 dated 23/8/2017, wherein this tribunal has held that selection of persons with 3-year diploma course is illegal since the prescribed qualification is 3.5 years diploma course, and the selection authority had no discretion in the matter of considering those persons who possessed only 3-year diploma in nursing course, also along with those who possessed the prescribed 3.5 year diploma in nursing qualification.
Just one.
All the selection.
Just one. Now you read further.
All the selection and appointments made were subject to the result of the application in the said case. We note that instead of issuing notice to those who are ineligible to be selected and appointed, the respondents have chosen to keep out eligible candidates, eligible persons who have the prescribed 3.5 year diploma course in the untenable contention of the selected ineligible persons having secured more average marks of the SLC and the ineligible 3-year diploma course than the applicants who had the requisite specified qualification. Hence, we are of the considered view that the applicants have made out a sufficiently strong case for our intervention in the matter for considering the case of the applicants for being selected to the post of staff nurse. The selection of the candidates who did not possess the 3.5 year diploma in nursing certificate is untenable under the recruitment rules, and they shall be notified of the same immediately in terms of the interim order of this tribunal in application number so and so dated 2/3/2010 forthwith and without any further delay, and their appointments rescinded since such appointments are illegal and therefore ab initio void. In this regard, the respondent shall verify the certificates of the selected candidates and the appointments of such of the candidates who do not possess the 3.5 year diploma in nursing certificate shall be reviewed and rescinded with due notice to them, since the appointment of candidates who do not have the requisite prescribed qualification is ab initio void as already held in application number so and so, which the respondent has failed to implement. Time for compliance is 6 months from the date of this order. The respondent shall consider the appointment of the applicants with regard to the list of eligible persons in the provisional list with due regard to reservation who have the requisite prescribed qualification. This exercise shall be done independent of the exercise of discharging persons covered by our direction in clause 1 above. For this purpose, the respondent shall consider the creating supernumerary posts for facilitating the appointment of the applicants if they are found to be eligible for appointment with regard to the prescribed qualification being possessed by them and not by several others who were actually selected illegally. Time for compliance is 3 months from the date of this order. A copy of the order shall be sent to the registrar of the additional chief secretary, principal secretary, health and family welfare committee, commissioner of health and family welfare, and the directorate of health and family welfare, and it shall be the responsibility of the additional chief secretary, principal secretary, health and family welfare department to monitor the compliance of the directions contained in this order, which is a matter of serious nature since selections have been made in violation of disregard to the rules, and there is no conscious and blatant attempt to gloss over the matter of implementation of the directions of this tribunal in application number 701 to 705 of 2010 dated so and so. In letter and spirit and frustrate grant of relief to the applicants by sheer procratization, I wage you endorsements as that impugned herein, that run contrary to the judgment in application number so and so, which itself has been made with considerable delay to deny relief to the applicants, besides avoidance of any action to correct the illegality of blatantly wrong selections and appointments made by the respondents.
So this order in application 701 to 705.
Yes.
2010.
Yes.
Has
It is there, Mala. It is there in kindly peruse.
That order is attained finality.
Yes. They have not challenged.
They have not challenged.
They have not. No. May I request my lord to peruse page number 12. Page number 12. Annex A1.
That is the application.
Same. In the same. State writ petition. Page number 12. Application number 701 to 70 of 2010. May I read the operative portion, Lord?
There the applicants were 3.5 year course.
Filed by us. Those applications were filed by us. KT has allowed our application, direct the respondents to consider us for appointment.
You are the same persons now also.
Same persons. Kindly see. Except one. Number 2, petitioner, respond number 1 here. We kindly see.
One nimsham.
all four.
No, ಅದರಲ್ಲಿ one is in that.
ಇಲ್ಲ ಅವ್ರಿಲ್ಲ ಒಟ್ಟು 1 ಅವ್ರಿಲ್ಲ ಇದರಲ್ಲಿ 2, 3, 4, 5.
ಯಾರು?
2 is ಶಿವಾನಂದ ಪಾಟೀಲ್. 2 is Ramesh Siddappa Desai. 3 Jyoti Mukasi. 5 Manjula Mukashi. They are the respondents before my lord in this writ petition.
Just one.
And this order has become final.
ಸ್ವಲ್ಪ ನಿಧಾನ. ಸ್ವಲ್ಪ ನಿಧಾನ.
My lord.
Slow. ಶಿವಾನಂದ ಪಾಟೀಲ್ is number 2.
State has not challenged this order. Sorry.
Application number 2, ಇದರಲ್ಲಿ 3, ಇದರಲ್ಲಿ 1. ಆಯ್ತಾ? ಮಂಜುಳ ಅದರಲ್ಲಿ 4, ಇದರಲ್ಲಿ ಅಲ್ಲ, ಮಂಜುಳ 5, ಇದರಲ್ಲಿ 4. ಮಂಜುಳ is 5 in the application, initial application, ಇದರಲ್ಲಿ 4. 5. 5 and 4. ಇವರಿಲ್ಲ. Jyoti is the only person who's not there.
Lord.
Jyoti is the only person who's not a party in the application.
No, all were parties.
Jyoti,
my lord. Kindly see. First
Jyoti is
title.
there, my lord. Vittal Biradar is not there.
Only one, except
Vittal
one.
Biradar.
just one.
My lord will find Jyoti's name. 3. Respondent number 3.
4. ಅದರಲ್ಲಿ applicant number
4 is
Jyoti.
Manjula. 4 is Manjula.
Just a minute.
In old case, my lord,
After the order in 701 to 705,
Yes.
they have not given appointment orders.
No, they did not give appointment order. Nor they have challenged this order. Sorry.
Two, 3/2010 interim order of the KAT.
Yes.
2/3/2010 interim order in that application.
Yes. 701.
Hello. Interim order in application 701 to 705.
Yes. 701.
Interim order we want to.
Granted. That has become absolute.
We want to see. ಅದೇನಾದ್ರು produce ಮಾಡಿದ್ದೀರಾ?
Nan madilla. But in the KAT order itself, they say that interim order granted earlier become all absolute. I kindly permit me to read that order.
ಏನಂತ order?
Hello, what is the order?
Stay
of the appointment.
Appointment of others.
Now those others have been given
Appointment. They are in hundreds. They are 3 years old, 3 years qualified.
No, now Mallikarjun, prima facie.
Please.
We forget about removing those people. That is different. But these people, prima facie, in application 701 to 705, there's an order already to include them in the selection list.
That is considered the representation.
No.
Kindly see, my lord.
Go
Page
to-
number 23, my lord.
No. Page 34 ಅಂತ ಇದೆ. Page
For the foregoing reasons, we
Correct.
are the considered view, the applicants have established that they are the eligible for selection to the post of staff nurses diploma in nursing under the notification so and so. And the representation is directed, consider the representation dated 22/1/2010, 23/1/2010, respectively, and include the name of the applicants in the provision list of the eligible candidates for verification of original documents within a period of 3 months.
Now you issued an endorsement.
Then
That-
we issued the endorsement. Yes.
That endorsement is set aside by the KAT.
That's why, my lord, that is set aside, my lord. Here, my lord, there is, my lord, whole process, my lord, we are selected the, my lord, relaxation of the, my lord, 3.5 year into 3 years course. That is also, my lord, question.
Correct.
No, my lord, other candidates is not before the KAT.
So forget about other candidates. In the KAT order, they say recruitment rule says 3.5. So you give appointment to them, isn't it? So let us for a moment forget about those selected candidates of 3 years, which according to them is illegal. Your appointment would be.
But we got it. There is already given, my lord, they are working.
Appointment order is given incorporating the number of this writ petition, saying that your appointment shall be subject to the result of this writ petition. Now our probation period is over.
Dishonorable
We are
court entry
overworking.
matter, my lord. Entry matter ಆಗಿದಲ್ಲ ಅವತ್ತು date entry matter
ಇಲ್ಲ.
Now, Mallikarjun.
we given they only produce the appointment order also.
Correct. So now you regularize their appointment.
But that's
then-
why, my lord, that is, my lord.
Huh.
Why we challenge before lordship, my lord. Other, my lord, not processing, my lord, our recruitment process is quashed by the, my lord, tribunal. Kindly see the operative portion, my lord.
We are not concerned with that.
No,
That's why,
just-
my lord, that is
just
before lordship.
We are not concerned.
just one. So now in the event, your appointment is made absolute.
Yes.
You have.
We have no grievance. Let them declare us for our probationary period.
That is,
Now.
To the extent of these applications, petitioners says, they say that is enough. And kindly see the Supreme Court judgment, where it says in between terms and condition cannot be changed.
Now, we'll do that. Insofar as those affected candidates were not before the KAT, nor before this court. KAT could not have set aside
Yes.
or passed any direction against them. Huh? And we leave it at that. You make them you regularize their appointment, their instrument.
Let that condition, let them remove it.
so, my lord, that regarding that, my lord, entire, my lord, that one will get that records, my lord. Then I will make, my lord, then you will also pass this order. Because, my lord, there is a direction by the tribunal. The selection of the candidates who did not possess the 3.5 year.
We are not concerned, my lord. We are not concerned.
One name, you are the safe survey. Certificate is untenable under the recruitment notes, and they shall be notified of the same immediately in terms of the interim order grant in so and so.
We'll only say.
That is not the subject matter here.
We'll only say that insofar as those who were selected, tribunal ought not to have commented upon the validity of the selection simply because they were not before the tribunal. Aita? And close it and regularize. We'll dispose it. So we'll only say that those who were not there, you could not have passed an adverse order against them. So the KAT was in error. Then regularize this and their instrument.
The petition is dismissed only to the extent of these respondents.
Lordship private to Thursday, my lord. So Wednesday, lordship private, my lord. We'll get to the, my lord, what is the position of that one. They are also issued the appointment order. There is no doubt, my lord.
No, once
It is
again,
true.
time and again he says there is no urgency. Sorry.
We'll close it on the next day.
Yeah,
Now,
definitely.
they have no grievance, whatever you want to do for the others, they are not. They
Yes,
want their appointment to be regular.
Yes, yes.
So we'll do that and modify the.
Please.
This is the matter in the orders list on 23rd. Mr. Hulappa has called us second roaster.
Lordship make it partnered also.
Mr. Hulappa has called us for second roaster because last time this case was still pending. So he's saying if it slips, go in the out.
That interim order, my lord,
Next-
you will also be able to get, my lord. I
Next week, my lord.
don't know
Yes,
what is
next
the
week.
interim
Any
order.
date next week.
We will clarify those who were not before the KAT could not have been visited by an adversary. List the matter and orders list on 23rd.
Please.
Grateful. Great.
Don't complicate. Ashte.
No, he has been, and he is known for it.
ನಿಮ್ದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಾನು ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
Yes.
23.
Milord 23, Milord, I represent the petitioner council. Milord, this is a case where the petitioner's mother was working on daily wages and initial appointment, Milord, was in 1987.
She died on 29/4/2021. Almost 34 years she has worked. And he moved an application for appointment on compassionate grounds. Now the page 81, my lord, a finding is recorded. When the deceased, page 81, my lord, in the middle, the sentence starts immediately left side after compassionate grounds. When the deceased Srimati Irama was not a government servant as of the date of her death, the question of her son's appointment on compassionate grounds under so and so does not arise at all. In fact, there is a scheme, those who are appointed prior to 1784, who have put in 10 years of service, but died before regularization. The policy, my lord, they are entitled for regularization. That is at page 35. And 38 is the reiteration. Page 38, my lord, the last portion.
Page 38 is a typed copy.
Yes, my lords.
Oh.
ಮೇಲೆ ಹೇಳಿದಂತೆ ದಿನಾಂಕ 1/7/84 ಮುಂಚೆ ನೇಮಕ ಆದ ದಿನಗೂಲಿ ನೌಕರರ ನೇಮಕದ ದಿನಾಂಕ 6/8/90 ಸದರಿ ಆದೇಶದ ಪ್ರಕಾರ ಸಕ್ರಮವನ್ನು ಪೂರ್ವಾನ್ವಯದಿಂದ ಮಾಡಿದ್ದಲ್ಲಿ ಅವರುಗಳು ಈ ಪೂರ್ವಾನ್ವಯ ದಿನಾಂಕದ ಸರ್ಕಾರಿ ನೌಕರರಾಗುತ್ತಾರೆ. ಸಕ್ರಮಗೊಳಿಸಿದ ಆದೇಶ ಹೊರಡಿಸುವುದಕ್ಕೆ ಮೊದಲೇ ಆದರೆ ಸಕ್ರಮಗೊಳಿಸಿ ಪೂರ್ವಾನ್ವಯಕ್ಕೆ ಜಾರಿಗೆ ಕೊಟ್ಟಿದ್ದ ದಿನಾಂಕ ನಂತರ ಅವರು ಮೃತವಾಗಿದ್ದಲ್ಲಿ ಅವರುಗಳು ಆ ದಿನಾಂಕದಂದು ಅಂದರೆ ಪೂರ್ವಾನ್ವಯವಾಗಿ ಜಾರಿಗೆ ಕೊಟ್ಟಿದ್ದ ದಿನಾಂಕದಂದು ಸರ್ಕಾರಿ ನೌಕರರೆಂದು ಪರಿಗಣಿಸಿ ಅವರ ಅವಲಂಬಿತರಿಗೆ ದಿನಾಂಕ 12/9/96 ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋನ್ಸು ಅನುಕಂಪದ ನೇಮಕಾತಿಗೆ ಸಂಬಂಧಿಸಿದ ನಿಯಮಗಳನ್ನು ಅನ್ವಯಿಸಬಹುದಾಗಿದೆ. Now, my lord, if the regularization is granted, those who are appointed after 1784, under this scheme, we are entitled for appointment and compassionate. This is the short question. In fact, under the 371J, I have produced the government order, Annexure A8. This is the presidential order, where power is delegated to the governor and the governor issued an order. Page 47, where the government can grant relaxation. Class 13B and 13C. This also should be read, my lord, for HK reason.
Now, the only contention they are raising is that you cannot outright reject stating rules are not applicable. In light of the government order deemed regularization, so they are entitled.
But rule, my lord, what rule says, my lord, that facilities has to be given only to the government servant. But admittedly, my lord, his mother, my lord, not appointed as a, my lord, not regularized service.
But A7, what do you say? A7.
The main GO is at page 85. Every year there should have been 240 days in 10 years.
There's only one point that you have to clarify.
Please, my lords.
This government order at page 38
Yes, my lords.
refers to those those appointed before 1784.
Correct, my lord. That is why I made a submission.
Ah.
Page 35, my lord, is the main government order.
Ah.
Appointments made prior to 1784, those who have put in 10 years of service, and further page 35 says 240 days in each year of service, 10 years. Totally 2,400 days they should have worked. Now this cutoff date has been removed by the division bench. What the division bench said, even if the persons were appointed after 1784, 10 years is the criteria and not the cutoff date. That's the position, my lords.
Correct, but only point is this government order.
Yes,
saying
my lord.
must be interpreted in terms of the relaxation by the division bench.
Correct, my lords. Otherwise, we are not entitled. But what the tribunal says at page 81, my lord, since the Irama is not a government servant, that is correct, my lord. But she was eligible for regularization on completion of 10 years. I think the Justice Ravindra J and Justice Manjunath J, my lord, in more than 3 division bench judgments, which has been offered in Malti Das case, persons were appointed after 1784 who have put in 10 years of service. On the principle of parity, my lord, the regularization has been granted.
Correct, but the KAT says you have not filed application for regularization after 10 years.
No. She died, my lord, on 29/4/2021.
But as on that date, KAT says she had not sought for regularization also. At para 8, at page 78,
Please, my lord.
it says she had not filed any application.
Correct.
Then it's little stretching it a little bit.
My lords, this is if the policy, my lord, on the basis of 10 years, if appointment is made prior to 1784 for appointment on a compassionate grounds is extended, then this honorable court and the Supreme Court again after 1784 10 years has been extended, but eligibility, my lord, on completion of 10 years, the LRs can agitate, my lords. An interpretation in favor of an employee, either on a question of fact and law, my lord, has to be interpreted in favor of the employees. That is how Justice Krishna has said, my lords.
When did she die?
My lord, 29/4/2021, case 30 minutes.
Now you
In fact,
place,
we have,
you place on record
please, my
that
lord.
LRs can agitate regarding regularization after death of, you place that authority. Let us have a look at it.
Please, my lord. I think in one matter, my lords, in one matter, when order of regularization was challenged in the Supreme Court, it was tagged along with the Uma Devi's case. And during the pendency of the appeal, my lord, the workman died. The apex court said the appeal was not entertained.
Now, for benefits of deemed regularization, even I have passed orders, but whether we can stretch it to compassionate appointment, we are not sure. Let us see. We'll have it sometime, week after next, we'll see.
Next week, your lordship.
We list the matter on 28th. Yes, next. Ready the Ganesh
Twenty-six, Shambhuling Parliament.
My lords, in memorandum of the criminal appeal 374 clause 2, my lords, I have filed in the principal district session judge court at the Raichur, my lords, in SC number 4 of 2016, in under section 504 and 302, my lords, has to be implement of the assigning judgment, my lords. It is the date of incident is 16/9/2015, my lords. And date of death of the
16/9/2015.
16/9/2015.
My lords. And timing is 7:30, my lords, PM. 7:13,
On the same day, she died.
same days,
She died.
died.
Where, in the hospital or in the house itself?
In house, my lords.
Alli ಸತ್ತಿದ್ದು.
House
On the
ಅಲ್ಲಿ, my
spot.
lords. Honda village and house. Honda village, house, my lords.
Hmm.
In crime number is 266 of 2015, my lords. Sindhunur rural PS, my lords.
Complaint with the complaint.
Complaint, please, my lords. In para number, kindly 2, serial number,
Page 2.
page 2,
Hmm. Who lodged the complaint?
my lords.
Who lodged the complaint?
Complainant is deceased brother, my lords.
Hmm. ಆಯ್ತು ಓದಿ.
ನಾನು ಈ
PW
ಮೇಲೆ ಕಳಿಸಿರುವ ವಿಳಾಸ, please.
PW ಎಷ್ಟು?
PW1, my lord.
PW1
PW1, my lord.
ಆಯ್ತು. ಹ್ಮ್.
ನಾನು ಈ ಮೇಲೆ ತಿಳಿಸಿರುವ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದು ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಉಪಜೀವನ ಮಾಡುತ್ತಿದ್ದೇನೆ. ನನ್ನ ತಂದೆಯ ತಾಯಿಯವರು ಹಾಗೂ ಈರಮ್ಮ, ಲಕ್ಷ್ಮಿ ಹಾಗೂ ನಾನು ಮಕ್ಕಳಿದ್ದು, ನನ್ನ ನನ್ನ ಅಕ್ಕಳಾದ ಈರಮ್ಮ ಇವಳು ಊರಿನಲ್ಲೇ ಮಾದಪ್ಪ ತಂದೆ ಸೊ ಅಂಡ್ ಸೊ ಅಕ್ಯೂಸ್ ನಂಬರ್ ಈತನೊಂದಿಗೆ ಲಗ್ನ ಮಾಡಿಕೊಟ್ಟಿದ್ದು, ಇವರಿಗೆ ಅಂಬಣ್ಣ ಮತ್ತು ಬಸಮ್ಮ ಮತ್ತು ಹುಲಿಗೆಮ್ಮ ಮತ್ತು ಹೇಮೇಶ್ ಈತರು ಮಕ್ಕಳಿದ್ದು, ಬಸವ ತೀರಿಕೊಂಡಿದ್ದು, ಅಂಬಣ್ಣ ಮನೆಯಲ್ಲಿ ಹುಟ್ಟಿದ್ದು, ಹುಳಿಗೆಮ್ಮ ಅಂದರೆ ಹಾವಿಗೆ ಸೊ ಅಂಡ್ ಸೊ ಲಗ್ನವನ್ನು ಮಾಡಿಕೊಟ್ಟಿದ್ದು. ಸದರಿ ಹುಳಿಗೆಮ್ಮ ಅವರು ಗಂಡನ ಹುಟ್ಟಿದ್ದರಿಂದ ತನ್ನ ತಂದೆ ತಾಯಿ ಹತ್ತಿರ ಇರುತ್ತಾಳೆ. ನಮ್ಮ ಅಕ್ಕಳ ಗಂಡನಾದ ಹನುಮಂತಪ್ಪ ಇಚ್ಛೆ ಕೂಡಿಕೊಂಡು ಕುಡಿಯುವ ಚಟ ಇದ್ದು, ಪ್ರತಿ ದಿವಸವೂ ಕುಡಿಯುವುದು ಬಂದು ಅಕ್ಕಳಿಗೆ ಕುಡಿಲಿಕ್ಕೆ ಹಣವನ್ನು ಕೊಡದ ಜಗಳ ಮಾಡುತ್ತಿದ್ದ, ಹೊಡೆಬಡೆ ಮಾಡುತ್ತಿದ್ದ. ಇದರಿಂದ ಮಾದಪ್ಪನ ಮಗನಾದ ಹನುಮೇಶ್ ಈತನ ಹೆಂಡತಿ ಪದ್ಮಾಳ ಪಕ್ಕದಲ್ಲೇ ಬೇರೆ ಮನೆ ಮಾಡಿ ವಾಸ ಮಾಡಿಕೊಂಡು.
Got married? ಯಾವಾಗ ಮದುವೆ ಆಗಿದ್ದು?
Is married by, it is accused has to be already 56 years, my lords.
ಆಯ್ತು, ಯಾವಾಗ, ಎಷ್ಟು ವರ್ಷದ ಹಿಂದೆ?
Approximately 20 years back, my
Yes.
lords. ವಾಸವಾಗಿದ್ದು, ನಮ್ಮ ಅಕ್ಕಳ ಗಂಡ ಅವರ ಮಗಳ ಹುಳಿಗೆಮ್ಮ ಒಂದೇ ಮನೆಯಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ ದಟ್ ಇಂದು ದಿನಾಂಕ 16/9/2015 ಸಾಯಂಕಾಲ 6 ಗಂಟೆ ಸುಮಾರಿಗೆ ನಾನು ನಮ್ಮ ಅಕ್ಕಳ ಮಗನಾದ ಹೇಮಂತೇಶ್ ಮತ್ತು ಈತನ ಹೆಂಡತಿ ಪದ್ಮಾಳ ಮಾತನಾಡಿ ಕುಳಿತಿದ್ದೇವೆ. ಪದ್ಮಾಳ ತಾಯಿ ಹನುಮಮ್ಮ ಬೋರೆಗಾಂವ್ ಹಾಗೂ ಮದುವೆ ದೇವಣ್ಣ ಬೋರೆಗಾಂವ್.
ಎಷ್ಟು? ಹನುಮೇಶ್ PW? ಹನುಮೇಶ್ examined as PW?
Examined PW. Hanmesh is Hanmesh PW2, my lords.
PW2, son.
Son, my lords. Deceased son and accused son, my lords.
Whether Padmamma examined?
Padmamma examining in PW5, my lord.
PW5. This Hanumamma Gorebala and Revanna Gorebala?
Savanna Goregowda is not examining, my lord.
Revanna also not examined.
Revanna also is not examining. Ramesh, what is there? Not examined.
Hi, good.
Please. ಇವರಿಬ್ಬರು ಸಹ ಬಂದಿದ್ದರು. ನಮ್ಮ ಅಕ್ಕನ ಮನೆಯಲ್ಲಿ ಅಡಿಗೆ ಮಾಡಿ ಮುಂದಿನ ಕೋಣೆಯಲ್ಲಿ ಕುಳಿತಿದ್ದಳು. ರಾತ್ರಿ 7:30 ಗಂಟೆ ಆಗಿರಬಹುದು. ಆಗ ನಮ್ಮ ಅಕ್ಕಳ ಗಂಡಾದ ಮಾದಪ್ಪ ಹೊರಗಿನಿಂದ ಮನೆಯೊಳಗೆ ಬಂದು ಅಕ್ಕಳಿಗೆ ಕುಡಿಲಿಕ್ಕೆ ಹಣ ಕೊಡುವಂತ ಕೇಳುತ್ತಿದ್ದ. ಆಗ ನಮ್ಮ ಅಕ್ಕ ತನ್ನ ಗಂಡನಿಗೆ ಕೊಡುವುದಿಲ್ಲ, ದುಡಿಯಲಿಕ್ಕೆ ಹಣ ದುಗುಡಿಗೂ ಬರುವುದಿಲ್ಲ, ನಾವು ದುಡಿದ ಹಣವನ್ನು ತಂದ ಖರ್ಚು ಮಾಡುತ್ತಾ ಇದ್ದರೆ ಸಂಸಾರ ಹಾಳಾಗುತ್ತದೆ ಅಂತ ಮಾವನಿಗೆ ಮಾದಪ್ಪನ ಮೇಲೆ ಸಿಟ್ಟಿನಿಂದ ಇದ್ದಳು. ನಮ್ಮ ಮಕ್ಕಳು ಈರಮ್ಮಳ ಒಲೆಯಲ್ಲಿ ಕುಳಿತು ಹಣವನ್ನು ಕೊಡಲಿಲ್ಲ ಅಂದರೆ ನಿನ್ನನ್ನೇ ಕೊಂದು ಬಿಡುತ್ತೇನೆ ಎಂದು. ಆಗ ನಮ್ಮ ಮಕ್ಕಳ ಇನ್ನು ಏನೂ ಮಾಡಿರುವುದಿಲ್ಲ ಎಂದು ನನ್ನಲ್ಲಿ ಹಣ ಕೇಳುತ್ತಿದ್ದಾನೆ ಎಂದು ನಮ್ಮ ಮಾವ ಕಬ್ಬಿಣದ ಉದುವಳನ್ನು ತೆಗೆದುಕೊಂಡು ನಮ್ಮ ಅಕ್ಕನ ಈರಮ್ಮಳಿಗೆ ಹಣೆಗೆ ಮೂಲೆಯ ಮೇಲೆ ಹೊಡೆದು ಮಲೆಯಿಂದ ಜೋರಾಗಿ ರಕ್ತವಾಗಿರುತ್ತದೆ. ಆದಾಗ ಅಕ್ಕನು ಅಂತ ಕೇಳಿ ಬೀಳುತ್ತದೆ. ದಟ್ಸ್ ಮೈ ಲಾರ್ಡ್ಸ್. ನಾವು ಹತ್ತಿರ ಹೋದಾಗ ಸುದ್ರಿ ಇದ್ದ ಮಾವಪ್ಪ ಹತ್ತಿರ ಬಂದು ನಿನ್ನನ್ನು ಕೊಂದು ಬಿಡುತ್ತೇನೆ ಅಂತ. ಆಗ ಸ್ವಲ್ಪ ಹೊತ್ತಿನಲ್ಲಿ ಹೊರ ನಿಂತು ಅಷ್ಟರಲ್ಲಿ ಜನರು ಬಂದು ಆಗ ಸೇರಿದ್ದ ಮಾವಪ್ಪನಿಗೆ ಹೊರಗೆ ಬಂದು ಓಡಿ ಹೋದ. ಊರಿನ ಗೌಡರ ಅಶೋಕ ಮತ್ತು ನಾಯಕ ಯಂಕಣ್ಣ ಮತ್ತು ಇತರರು ಹುಡುಕಿಕೊಂಡು ಮಾದಪ್ಪನಿಗೆ ಗುಡಿಯ ಹತ್ತಿರ ಮರಿಯಮ್ಮನ ಗುಡಿ ಹತ್ತಿರ ಕೂಡಿಸಿರುತ್ತಾರೆ. ನಂತರ ಅವಳಿಗೆ ಹೊರಗೆ ತರಲು ಅಕ್ರಮ ಈರಳು ಮೃತಪಟ್ಟಿರುತ್ತಾಳೆ. ಹೆಣವನ್ನು ಬಾಗಿಲು ಮುಚ್ಚಿ ರಕ್ತಗಾಭೀರವಾಗಿರುತ್ತದೆ ಎಂದು ರಕ್ತ ಬಂಡೆಯ ಮೇಲೆ ಸುರಿದಿರುತ್ತದೆ. ಸದರಿ ಮಾವ ತೆಗೆದುಕೊಂಡ ಕುಡಲಿಯನ್ನು ಹಣವನ್ನು ಕೊಡಲಿಕ್ಕಂತ ಈರಮ್ಮಳಿಗೆ ಕಬ್ಬಿಣದ ಉದುವಳವನ್ನು ತೆಗೆದು ಹಣೆಯ ಮೇಲೆ ಮತ್ತು ಮೊಲೆಯ ಮೇಲೆ ಜೋರಾಗಿ ಹೊಡೆದಿರುವುದ ಕಾರಣಕ್ಕಾಗಿ ಸದರಿ ಮಾವ ಹನುಮಂತ 5 ವರ್ಷ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸುವ ವಿನಂತಿ. ಮೈ ಲಾರ್ಡ್ಸ್.
Monday, we'll continue on Monday.
Please continue kindly for Tuesday. I am ready. I am not Monday.
Monday ಮುಗಿಸೋಣ.
I am not here.
ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ಎಲ್ಲೂ ಊರ್ ಹೊರಗಡೆ ಹೋಗ್ತಿಲ್ಲ ತಾನೆ?
ಇಲ್ಲ, ಊರ್ ಹೊರಗಡೆ ಹೋಗ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ. That's it.
PCL ಹಾಕ್ತೀರಿ? PCL ಎಪ್ಪಿರ್ ಆಗಿ?
Yes, please.
ಮುಗಿಸ್ಬಿಡೋಣ Monday.
3 PM Monday. Please.
ಆಯ್ತು.
Please, VC I will there. Please.
Sir. Serial number 5, sir, 2168, sir.
Serial number
5, sir.
5.
No, sir.
Mike use.
Serial number 5, sir, 2168, sir. Statement of objection now file ಮಾಡಿ sir ಮೊದಲು. Respond number 4 ಲಿಂದ.
ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ affidavit of R4 single set ಅಲ್ಲಿ ಫೈಲ್ ಆಗಿದೆ?
Sir. Earlier we have filed.
Single set.
Sir,
Single set ಅಲ್ಲಿ ಫೈಲ್ ಆಗಿದೆ.
ಮತ್ತೆ ನಾನು ರಿವೈಸ್ಡ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸರ್. ರಿವೈಸ್ಡ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸರ್.
ನೀವು ಎರಡನೇ ಸತಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ. You should be regular to the court.
Please.
ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ? ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡೋಣ. Tuesday we'll have it. You come Tuesday.
Right.
You must be present when the matter is called.
Correct.
They cancel ಮಾಡಿ. Relist on Tuesday. ಅದು second list, second set of A4's affidavit has to be filed.
Sir.
Tuesday ಬರ್ರಿ ಸರ್. ಅದನ್ನ ಒಂದು ಇವತ್ತೇ ಫೈಲ್ ಮಾಡ್ಬಿಡ್ರಿ. ನಾನು ಜೆರಾಕ್ಸ್ ಸರ್ ದಿವಸ ಹಿಂಗಲ್ಲ. ಮಾಡ್ಬಿಡ್ರಿ, ರೆಡಿ ಮಾಡ್ಬಿಡ್ರಿ. ನಾರಾಯಣ ಇದು ನೀವು ಮಾಡಂಗಿಲ್ಲ.
Sir, Dhananjay sir ಹೇಳ್ಬಿಟ್ಟು number 5 cancel ಮಾಡಿ release just
ಇಲ್ಲ ಕೊಡ್ಬೇಕು ಅವ್ರ ಬೋರ್ಡ್ ಬಂದಿಲ್ಲ ಕೊಡ್ತೀನಿ. ನೆನ್ಪ್ ಮಾಡ್ಕೊಡು. ಅಲ್ಲೊಂದು SWK ಅಂತಂದ್ ಐತ್ ನೋಡ್ರಿ, ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲಿ ಬುಕ್ ಮೇಲೆ ಅದನ್ನ ಕೊಟ್ರೇನ? ಕೊಟ್ರಲ್ಲ? ಇವ್ರಿಗೆ ಹೇಳ್ರಿ, ಯಾರಿಗೆ ಮಠಪತಿ ಸರ್ಗೆ, ಇದು ಸಾಹೇಬ್ರೇನೋ ಊರ್ಗ್ ಹೋಯ್ತಾರಂತೆ, ಎಲ್ಲಿ ಕೇಳ್ಬಿಟ್ಟು ಹಾಕಿಸ್ತಾರೆ. ರೈಟ್ ಆಯ್ತು.
ಇಲ್ಲಿ 7 ಗಂಟೆ ಲಿಸ್ಟ್ ಹೊಡಗೆ ಸರ್ ನೋ ಕಿಸಿದ್ ಅಂತ ಬಂದಿತ್ತು ಅದ್ರ ಆರಾಮ್ ಕುಂದೆ ನಾನು 9 ಗಂಟೆಗೆ ಒಂದು ಬೇರೆ ಲಿಸ್ಟ್ ಕೊಟ್ಟಂದ ಅನಿಯಾ 25 ಪಾಸ್ ಓವರ್ ಹೌದಾ 58 ಇದೆ ಪಾಸ್ವರ್ಡ್ 25 ಇಲ್ಲ ಹಾಂ 58 ಬರ್ತದೆ ಕಂಟಿನ್ಯೂ ಪಾಸ್ವರ್ಡ್ 25 ಒಂದಿರ್ತಲ್ಲ ಪಾಸ್ವರ್ಡ್ 25 ಹರೀಶ್ ಮೇಗೂರ್ ಪಾಸ್ವರ್ಡ್ ಎಸ್ ಥ್ಯಾಂಕ್ ಯು ಈಗ ಅವ್ರು 3:30 ಇಲ್ಲೇ ಅಲ್ಲೇ ಹೋಗ್ತಾರೆ ಸಾವಿರ ಅಲ್ಲೇ ಹೋಗ್ತಾರೆ ಇಲ್ಲಿ ಡಿ ಬಿ ಮ್ಯಾಟ್ ಓ ಆಯ್ತು ಆಯ್ತು
ಕಲಬುರ್ಗಿ ಬೆಂಚಿಂದ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್ ಧಾರವಾಡದಿಂದ.
ಹಲೋ
ಸರ್ ಕಲಬುರ್ಗಿ ಬೆಂಚಿಂದ ನಾ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮಾತಾಡುದು.
ಹಾ ಮೇಡಮ್.
ಸರ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕಿದಾರ ಅಂತ ಸಾಹೇಬ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ, ಅಲ್ಲಿ ಬಂದಿರೋದಾ ಸರ್?
ಮೇಡಮ್ ಒಂದ್ ನಿಮಿಷ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್ ಆಚೆ ಇದ್ದಾರೆ, ಬರ್ತಾರೆ.
ಹೌದಾ?
And neither have we received any.
ಸರ್ ಕಲಬುರ್ಗಿ ಬೆಂಚಿಂದ.
ಹಲೋ
ಸರ್ ಕಲಬುರ್ಗಿ ಬೆಂಚಿಂದ.
ಹಾ
ಸರ್ ನೀವು ಇದು ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಏನಾದ್ರು ಹಾಕಿದಾರ?
ಇಲ್ಲ 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 ಹಾಕಿಲ್ಲ, ಇಬ್ರು ಹಾಕಿಲ್ಲ.
ಸರಿ.
ಹಾ.
ಈ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದಾರ ಸರ್?
ಆಲ್ ರೈಟ್ ಮ್ಯಾಮ್.
ಹೊರಟಿದ್ದಾರೆ ಸರ್?
ಎಸ್.
ಸಾಹೇಬ್ರು ಹೊರಟಿದ್ದಾರೆ ಮೇಡಮ್. ಇದು
ಸರಿ, ಯಾವ ತಗೊಳ್ತಾರೆ? ಮಾಡ್ತಾರೆ.
Second list 57,000.
ಸರ್ ಸಾಹೇಬ್ರು ಹೊರಟಿದ್ದಾರೆ, ಬರ್ತಾ ಇದ್ದಾರೆ ಸರ್, ಫೋಟೋ ಆಫೀಸರ್ ಸರ್. As pertains to principal bench, serial number 1, government advocate Nishant Devi for respondent.
Lord, Lord, your lordships have directed
Yes,
for filing of written synopsis, my lord. I have not been able to complete it, my lord. I'll file it in a matter of 2 weeks' time, my lord, and we would request that if this matter can be taken up in the first week of March, my lord, then
no, first you file.
yes, my lord.
But you have to serve a copy on the other side so that they will also.
Yes, my lord.
But you could have filed by now, isn't it?
I could have filed, my lord. In fact, I have commenced. It's almost complete, my lord. I'll file it in less than 10 days' time, my lord. I'll also serve it on the other side, my lord.
I'll fix a date after you
Can
file.
you be given one additional week, my lords? My synopsis is ready. I will just look into their contentions and try to answer that one.
Yes, yes. Learned additional advocate general submits that written submissions will be filed within
2 weeks, your lordship may say
within 2
outer limit.
weeks. Within 2 weeks. Advance copy of which is to be served on the counsel for the respondent, who is then to file his written submissions within 10 days thereafter.
Please, my lords.
Date will be fixed. Matter is adjourned.
My lords have given a date, my lords.
I'll
For
fix
listing.
it because we are in a bench.
I understand, my lords. Please.
So we'll fix it, but you file.
We'll
Please,
do
my
it. Sorry
Great,
for the
sir.
lapse.
Yeah,